Good afternoon. It is February 10th, 2022, and welcome to the Ways and Means Committee afternoon bill hearings. We will begin with House Bill 334 with Delegate Ampalera, and whenever you're ready, Delegate Ampalera, you can begin. You're on mute, though.
There we go. You said 334. I have it as 336. This is the superintendent.
Okay, you want to do that one first? That's fine. You can do, you have two.
Okay, I thought I was just doing one, but I'll do the superintendent first. Okay, well, congratulations, Madam Chair, on your appointment.
Thank you.
Look forward to working to you in this capacity.
Thank you.
All right, so House Bill 336 is a new idea out of the box. We've had a lot of discussion with across the country over superintendents, and we've had discussions about superintendents in Maryland. So what this bill would do in Harford County, it would let the citizens of Harford County elect their superintendent of public schools. So when you slide down to page 4 of the bill, it talks about qualifications and a change, as many of you probably have dealt with hospital systems and other businesses. The head of a hospital system may not be a doctor, it may be a CPA, but unfortunately right now there's a very narrow window of who can actually be a superintendent. So just to give you an example of some of the qualifications under this bill that would qualify: a master's degree and at least 20 years of experience in the respective field, meaning you could be an attorney, you could be an accountant, has a doctorate degree and at least 10 years of experience in that field, which is the same. At least 5 years of experience as a principal of a public school system anywhere in the United States, has at least 5 years experience as the dean of any institute of higher education in any state. So you could be the dean of Harford Community College and you wouldn't qualify today to be a superintendent. So that's some of the changes to open up the field to some of the people that would be qualified. And then next it goes on to talk about the assistant superintendent. So the assistant superintendent would have to have the same qualifications as a superintendent would, but he would be chosen by the superintendent, and that would be with the consent of the school board. So he would have to run that by the school board, and he's got 60 days to create that position. Then we talk about replacement and recall. So if for some reason the superintendent couldn't move forward in that position, then the assistant superintendent would take over that position till the end of that election term. There is recall because some people feel they're not being serviced properly by the superintendent. And right now, really, a superintendent is the way we appoint superintendents. They're not really answerable to the students or the teachers or the taxpayers of the county. So this gives the people a process to recall the superintendent. And then we move down to like around page 8, and it talks about the salary. And there's a lot of questions on salary. I mean, we make the salary for the sheriff, and we make the salary for the county executive and for the register of wills, but nobody knows what the salary of the superintendent's going to be when they're appointed. So what this does, creates a situation where the superintendent can make no less money than the county executive of the county, and the school board can give him a raise up to 20% if they feel he's doing a good job. So there's an incentive for the superintendent to do a good job. There's rules for the election. So it'd be a nonpartisan race. The way it's drawn up is that if there's 3 people running for superintendent, they would run in the primary. If there's only 2, they run in the general. The 3 or 4 or 10 that are running in the primary, the top 2 will advance to the general election, and then those 2 will stand to run for the county executive. And this may sound a little unusual, but it is the way it's done in other places. If for some reason there was a tie which doesn't happen often, rather than a long drawn out process, there is just a drawing of straws to see which one of the two actually will be the superintendent. And of course, in a case like that, you'd hope the superintendent would then pick the other as the assistant superintendent. So my feeling, and others I've spoken with, believe that our children are our most valuable asset. It would be nice to know what the person who's in charge of that asset stands for, what they believe. Are they going to fight that we have certain types of education, like vocational education, which is very lacking in our state right now? And I know, I don't care whether you're a Democrat or Republican, whether you're from Western Maryland or Prince George's County, people are asking for that. So this is a new concept outside the box to put in place a superintendent who actually is answerable to the taxpayer, is answerable to the students, answerable to the school teacher, and it allows us, if we don't think they're doing a good job in 4 years, we can get rid of them. The bill does say that they can run for 3 consecutive terms, but they have to win those terms. So I know right now, our superintendent of Harford County, if he had to run for election, he would not win because the people are very upset with the way he's handled our system. And that's the bill. I hope I didn't go too long, Madam Chair.
Thank you. Are there any questions for Delegate Ampalera? Okay, seeing none, thank you. That concludes the testimony
Thank
on House Bill 336. Now I'm going to call 334. Are you doing 334?
Is that the Baltimore County Superintendent bill?
I have this, both of them say Harford County on them.
Okay, well, this is the school board bill.
Yeah, Board of Education.
Yes,
Yes.
the Board of Education. So we've had discussions about this in Harford County today. And what this does, it really makes Harford County like most of the other counties where they would have an elected school board. One of the problems that we have faced in Harford County is there's only 6 councilmatic seats. So this bill would have 6 elected members, 1 appointed by the county executive. In meetings with the public, they did not want someone running countywide for that 7th seat. And also in those meetings, people said that they, even though the county executive was appointing them, they didn't think that person should be a full voting member. So under this bill, the appointed member would be able to vote on anything that the student member was able to vote for, or to break any ties, because the real reason that person is there is to break the ties, if there are ties. The county executive will appoint that person for 2-year terms. So if he wants to change them, he will be able to. And what's interesting about this bill, which we have talked to many stakeholders and former members and members of the school boards, is it will give them an attorney and it will give them a financial advisor, because our school budgets are large and there are many questions that they have to require, the information from the school's attorney and the school's financial advisor. But, at times they're adversaries and they should have a separate counsel. I mean, we have a liquor board in Harford County, and the liquor board has its own attorney and it has its own financial advisor. And I think if we can do that for a liquor board, we definitely should be able to do that for our children in the school system, so that we have someone else besides the school system that can answer those questions. There's a situation set up if the person needs to be replaced in the bill, which basically says that, the board will post and advertise the openings so people can go. They do not have to make the final choice in an open meeting, so they can have fair discussions about the individuals, the same as they would have any other personnel issue. And finally, what was that last point? There has been request over time to increase the stipends for the board members. So this bill does put an increase in the amount of the stipends for the board member. And that's pretty much the bill. I think it's fair that Harford County is treated the way 90-some% of the other counties are, that we get to elect our school board members except for this one. A good way to fix it would, instead of having 6 councilmatic seats, we'd have 7, and then that would avoid that argument. But unfortunately, right now, we only have 6 councilmatic seats. So the appointed member is necessary to fill that final role. Thank you.
Thank you. Are there any questions? Delegate Lasanti?
Thank you, Madam Chair and Delegate Imploria. Thanks for this bill, and thanks for the robust discussion today in delegation. But I have a question when you were drafting this bill, because there's one particular component here that I think is really important, not only for our school board, but for all the school boards, and that's ensuring that there is technical support staff for the Board of Education. The financial advisor and the attorney, those are very critical pieces. I mean, we have those here to help us make our decisions. And I was wondering if in your research, is that common among boards of educations around the state, and we just haven't done it yet, or is this a new staffing role that you're suggesting?
Well, it is a new staffing role. Other jurisdictions may have it. I didn't actually look into that. But, the truth of the matter is budgets are complicated. And the budget for our school is 50% of the county's budget. And it is the board who is responsible for going through that and over that. So they should have someone who's independent of the school system assisting them. Many of the rules that they try to put into effect, they are told by the school attorney, oh, well, we can't do it for this reason or that reason. And, we should always ask a second opinion, and they should have a second opinion. And just to show that this is reasonable the way we're asking for it, it's a small salary for 2 part-time people. I don't believe that we need to build government up and have a full-time attorney for this and a full-time person working on the budget. These people should be there. Basically, the attorney should attend the meetings and kind of watch what's going on and advise and consent to different issues that come up that the school board asks of him. And the budget analyst really just needs to be there during the budget process. And there's nothing to prevent the school board from hiring an attorney that does both jobs. So if they wanted to do that, because many attorneys are accountants and attorneys are allowed to practice as accountants, even if they aren't CPA. So that is the purpose of having that extra eyes on the field watching what's going on.
Delegate Ebersol?
Thank you, Madam Chair. Just curious, this person who would be advising the board on their budget, how would they be selected? Who would appoint them?
The board would. The board would select them, and they would be employees of the board. They would work for the board.
Thank you.
Rather than be employees of the school system and work for the school system.
Are there any more questions for Delegate Imploria? Okay, seeing none, thank you. That concludes the testimony on House Bill 334. Moving on to House Bill 347, Delegate Boatler, whenever you're ready. You're on mute, sir. Delegate, you're on mute.
There you go. Got me?
Yep.
All right, great. Thank you. Good afternoon, Chair Atterbury and fellow members of the Ways and Means Committee. I'm here to discuss today House Bill 347, Baltimore County. This is a mirror of the bill that you just heard, which was House Bill 336. Dealing with Baltimore County, in this case, superintendent, election and recall procedures and compensation. HB 347 will make the county superintendent an electable position that Baltimore County's voters would choose every 4 years. This bill outlines a residency requirement of 30 days before individuals can file for their candidacy and specifies the level of experience they must have to qualify as a candidate. As you heard in the previous bill, it is the same conditions that the superintendent must have a master's degree with 20 20 years experience in their field, or a doctoral degree with 10 years, or they have to have at least 5 years experience as a public school principal or a dean of an institution of higher education. A candidate may not qualify by being nominated by a political party, making this a nonpartisan election. And once elected, the county superintendent is limited to 3 consecutive terms. Now, the newly elected county superintendent, they shall be responsible for electing an assistant superintendent, again, with the approval of the county board. Now, the assistant superintendent selected, in case there is a vacancy, they will become the superintendent of the schools, and they shall have the authority to get them to select an intern assistant superintendent, again, subject to the approval of the county board. The compensation plan is the same, that it's got to be at least equal to the county executive and no more than 20%. Also in the bill is a provision that recall provision to remove the county as separate county superintendent by supermajority vote, but it also outlines the process for the voters to recall the county superintendent and specifies the condition under which the voters can initiate that process. Much of the bill's fiscal impact would only come from the process of recalling a recall election, but only in the case of a recall collection. This bill is necessary because it will allow the voters of Baltimore County to hold the county superintendent accountable through the election and recall process. It will also ensure the position is given based on qualifications and experience and not on partisanship. This bill will maintain a high selection of standards while increasing the public's involvement in our county public school system. Something that I think is important for members of this committee to understand that, and this is kind of true, I think, in most county budgets around the state. For instance, in Baltimore County, 49% of the budget is controlled by the superintendent, with another 5 to 8% that is sort of like maintenance, construction type fees. Now, what I find interesting is that the voters get to elect a superintendent, or not a superintendent, a county executive. And when they elect a county executive, he doesn't, he pretty much controls maybe 50% of the county budget. And he is responsible to answer to them. And it also is a means that if the voters do not like particularly what the county executive wants to do, they are able to voice their opinions, and the county executive then can decide whether or not to change what he's doing or just move forward. The problem that I've seen, and please understand, I'm not picking on superintendents, but the problem that I see is that when we try to approach the superintendent, whether it's with the county, at least this is what I've seen in Baltimore County, whether the board approaches the superintendent, or even folks, ordinary citizens approach the superintendent. The superintendent's not obligated to do anything. He's not even obligated to respond to them. And I think that the voters should have the right, if you're electing one person and he controls 50% of the budget and you have a voice in that process, I think we should also be able to give the voters a voice in the process and what's going on the other 50% of the individual that controls that budget, the other half of the budget. So with that, as the other sponsor had said, this is kind of like thinking out of the box a little bit. And I think sometimes we need to do that as elected officials. But again, I want to emphasize, this is not a reflection of who the county superintendent is at this time. I think he's doing an excellent job, but I think that folks are getting very upset over some of the direction that he is taken the school system, and they just want a voice. That's what they want. And I think this is about transparency. So with that, I urge the committee to give HB 347 a favorable report. And I thank you for your time.
Thank you. Are there any questions for the delegate? Okay, seeing none, that concludes the testimony on House Bill 347. House Bill 345, the hearing is canceled at the request of the sponsor. Moving on to House Bill 380, it is a Montgomery County bill, and it is my understanding that Delegate Palakovich-Carr will be presenting the bill. So whenever you're ready.
Thank you, Madam Chair. So good afternoon, colleagues. For the record, Delegate Julie Palakovich-Carr filling in for Delegate David Moon, who was the local bill sponsor, to present this Montgomery County local bill. Delegate Moon is currently presiding over hearings in judiciary and is sorry that he cannot be here himself. By way of background, we currently have 8 seats on the Montgomery County Board of Education. 2 of those seats are elected at large. There's also 1 student member, and the remaining 5 seats are district-based seats, which means that the candidates have to live in a certain part of the county to run for the seat, but are elected at large for the whole county. This bill would reform the system to retain the existing 2 at-large seats and the student member, but elect the 5 other seats in district rather than at large. The current system makes it harder for grassroots representation on our school board, given the demands of the race. Typically, candidates are only raising about $10,000 or $20,000 for these races in Montgomery County, but have to reach all of the voters in a county with more than 1 million residents. And it's just not that realistic that these candidates can reach such a big pool of voters on such a small budget. This bill did pass our Montgomery County House delegation unanimously. The bill is supported by our county executive and the League of Women Voters. And on behalf of the delegation, I ask for a favorable report for this local bill. Thank you.
Thank you. Are there any questions? Okay, seeing none, that concludes the testimony on House Bill 380. Thank you, Delegate Palakovich-Carr. Moving on to Delegate Ebersol, House Bill 476. Whenever you're ready, sir.
Thank you, Madam Chair. This is a Baltimore County bill dealing with a correction that needs to be made in the appointment of the Board of Education members. Baltimore County has currently a hybrid board where 7 members are elected in their respective districts, as Delegate Palakovich-Carr just described, that Montgomery County would like to move to, but 4 members, after being nominated by a nominating committee, quite an extensive group of people. They nominate twice the number of people that they need to fill. So in this case, they would nominate 8 each time we come to an election cycle. 4 would be selected by the governor to be appointed. Unfortunately, their work will not be done until after the primary election, and has been brought to our attention and confirmed by the Attorney General that a governor who has not run in or did not win their primary is considered the vernacular lame duck and may not make appointments. And so even though we generally appoint our board members in the first week in December, these 4 members would not be permitted to be appointed because they would not be allowed to be selected by the governor. So this bill simply makes a correction in that generally, without regard to what happened that particular year, the governor who is inaugurated in that election year in January will make the appointment between his or her inauguration and the 1st of February, and then they will be appointed. We will offer an amendment to this bill because someone has come up with an even better solution after the bill was written that will allow the appointed members to serve for 2 years now, but then going forward for 4 years after that, they would then be appointed and selected and appointed in presidential election years, and we would never have a lame duck governor in that situation. So we will present this bill to Baltimore County delegation as a fix that needs to be done this year still, but going forward, a more permanent and perhaps more elegant fix to the problem that was created that was unanticipated, but we certainly realized it last session.
Are there any questions for Delegate Ebersol? Okay, seeing none, thank you. That concludes the testimony on House Bill 476. I jumped the gun and I skipped Delegate Wells. My apologies. House Bill 433. My dear, you know I would never skip.
I know.
You. Love you. Go
It's
ahead.
all like the tiles behind behind you.
Yes.
So for the record, it's a pleasure to be here again today, Chair Atterbury, members of the committee. For the record, my name is Delegate Melissa Wells. I'm here to testify on HB 432. HB 432 is a local measure to increase the current number of student members on the Baltimore City Board of School Commissioners from 1 to 2. It will also give the student commissioners full voting rights and a voice with more impact on decisions that affect them. And third, it will create a commission to study compensation so that we can create more opportunities to serve our city, our schools, and our children without the hurdle of making it work financially. This legislation is backed by a large coalition called the Votes Coalition. I would like to give credit to those who have worked with our office over the last 2 years to continue to make a push for reform to better serve our students. And I urge you to read submitted testimony to see the passion that they bring to this and the hard work they have done. HB 432 has not yet been heard in the Baltimore City delegation. I know this committee will wait to hear before making any decisions. So I thank you for your time in hearing this legislation, and I'm happy to answer any questions you may have. Thank you.
Thank you. Are there any questions for Delegate Wells? Okay, seeing none. Thank you, Delegate Wells. That concludes the testimony on House Bill 433. Now calling Delegate Ebersol again, House Bill 495, whenever you're ready.
Thank you, Madam Chair, Mr. Vice Chair, and members of the committee. This bill is a more substantial one than the last one for your interest. This is a bill that would ask local school boards to create and keep a policy on student demonstrations. My time as a teacher, I've been consistently impressed with the maturity and awareness of students I teach. They are not only in tune with policies and issues of the day, but many of them are eager to participate actively in establishing and influencing policy. And one way for them to do this is through peaceful and productive demonstration. It's important in the school setting that they understand the parameters both for themselves and for the school setting while experiencing the opportunity. This legislation will help to clarify to students in a consistent and predictable manner the way for them to be able to demonstrate and express themselves, helping to clear the way for them to do that. But it will also establish basic guidelines to protect the educational setting for instruction as well. Demonstrating is an excellent educational tool as well as a way for students to actually influence policy. And I think we should encourage it, but we should make sure it doesn't interrupt education. This bill seeks to do both. Each local school system will be required to establish a demonstration policy for students that would allow students to experience this set of rules in arranging and carrying out a demonstration on school property or at a school event. Among the major points that must be honored in such a policy are: 1, a definition of what would be a peaceful student demonstration as well as what would not be; 2, protections of health, safety, and welfare of students and school personnel in authorizing demonstrations; 3, conditions students must adhere to in terms of notification and in terms of not disrupting school; 4, protections against excessive and unnecessary punishments of students if they are demonstrating. Specifically, the policy must contain guidelines for times and places and manner of expression for demonstrations that will be allowed, and limitations on language that has the intent to harass, threaten, or intimidate others. This bill is often perceived as being terribly permissive. It's actually a two-edged sword that helps to protect students so they know what the rules are and they can follow them productively. At the same time, as a teacher, I believe in protecting the instructional integrity of the school. I believe this does both, and I thank you all very much for your time.
Thank you. Are there any questions for Delegate Ebersol? Okay, seeing none, that concludes the testimony on House Bill 495. Moving on, House Bill 435, Delegate Hill, whenever you're ready. Oh, I'm sorry. I see you. I'm sorry. Going back. Ebersol, hop back on here.
I'm sorry. I have a question. Thank you.
I'm here.
Thank you, Delegate Ebersol, for the legislation. I have a question as relates to, one, is this bill patterned after a bill that exists somewhere else, one? And two, what consideration or restraints are you applying when you have school bus? That is the one that sort of jumped out at me. People protest on a school bus.
Right. We put the school bus in there for safety. People feel like we're being permissive and telling kids they can demonstrate on a school bus. It just says they have to have a policy about demonstrating on school buses.
Okay.
School systems could actually prohibit demonstrations on moving school buses or on school buses, but we felt like that should be part of their purview a place that they could comment that that's sort of not on school property, but it is aboard school property. So the idea there is, as I said, sometimes part of this bill is to actually keep people safe. And we felt like allowing the school system to include, or encouraging them at least, to include school buses as part of their policy would actually help them to promote safety.
All right, thank you.
Vice Chair has a question.
Okay.
Thank you, Madam Chair.
I like the Vice Chair.
Hey, Delegate Eversole. Did we pass this bill last year in the same?
We did pass this bill last year, and I haven't changed it at all.
Okay, thank you.
Any other questions for Delegate Eversole? Okay, seeing none. Now that concludes the testimony on House Bill 495. Thank you. Okay, now Delegate Hill. House
right,
Bill
thank you.
435. Yep.
Thank you. And first of all, Madam Chair, it's a pleasure to sit before you. This is my first opportunity here before you in your new position. Congratulations.
Thank you.
And good afternoon, Vice Chair Washington and members of the committee. For the record, I'm Terry Hill, and I'm presenting House Bill 435, Youth Sports Programs, Registrations, Personnel, and Policy. What this bill does simply is it allows or requires that the best practices and standards that are currently in use by our Parks and Rec and our youth sports organizations in the state to be used as a standard for all of our youth sports programs below the high school level, meaning, Pee-wee to preteen. This is with respect to background checks and safety training for personnel who are responsible for the health and welfare of our youngest athletes. There are proposed amendments that I believe you have in your packet, and they would simply do four things. One, clarify that the provisions in the bill only apply to youth sports below the high school level of play. They remove additional prerequisites for a youth athlete to receive medical clearance, returning them to full academic activities in order to be cleared for return to play, as that was felt to be redundant, and the medical community generally would have done that without being told. And it also removes unnecessary, costly, and overly burdensome inclusion of a credit check as part of a criminal background check. And then there's a separate amendment that adds the word athletic in front of trainer to specify that we're talking about athletic trainers in the bill. With respect to health and safety, our youngest athletes certainly should deserve at least an equal level of protection as those that we give to our high school athletes. But the standards and practices at that younger level are at best uneven. At high school level, we surround our kids with professionals, the coaches, the trainers, the staff that are there, and even in the community, whether it's in the independent leagues, in the Parks and Recs leagues, or otherwise based in the community, there are a cadre of trained professionals around them to secure their safety. We don't do the same consistency at the younger level, where parent volunteers who do a great job and are well-meaning take on most of those responsibilities. And again, the training and expectations seem to be a little uneven. So HB 435 would require that coaches, team administrators, and volunteers for youth sports programs under the high school level be trained as well in child safety, heat illness recognition and prevention, as well as concussion awareness. They would undergo the standard background check that the National Recreation and Parks Association employs, and they would be required that the program maintain a registry of those who have been cleared, and that they carry an ID badge with a photo, and that we protect our children from predators, frankly, by making sure that the folks who come onto the field of play are wearing their badges. So that would be it. And it is not as costly as people would have you believe. And I know, because a couple of years ago, when we first introduced the bill, the coaches asked me to go through the training. I went through an online program, and it was less than $5. And as was also pointed out, most of the leagues can afford the trophies. So the additional $1 to $5 to $10 per volunteer should not, bankrupt even the less affluent leagues. So no one can argue with the enormous benefits that are gained by participation in organized sports. But by applying best practices in a statewide minimal standard, we can better meet our shared responsibility for the health and safety of our youngest constituents. and I respectfully request adoption of the amendments and a favorable report on the bill. Thank you.
Thank you. Next, for 2 minutes, we have Josh Howe.
Good afternoon, Madam Chair and members of the committee. My name is Joshua Howe. I am with Compass Government Relations here on behalf of the Maryland Association for Justice, here with favorable with amendments report. As drafted, House Bill 435 requires a youth sports program to provide specified health and safety information to each parent or guardian who registers a youth athlete, and the parent or guardian must submit a signed acknowledgement of receipt of this information. This provision is outlined on page 5 of the bill. MAJ has concerns with language beginning on page 5, part C, line 17. As drafted, the language requires a youth sport program to develop and require parents to sign a liability disclaimer or waiver. MAJ is critical of legislative grants of immunities and often tries to offer clarifying amendments on immunity provisions. As currently drafted, this could be interpreted to require parents of youth athletes to preemptively waive right of recovery against potential injury caused by youth sport program personnel, irrespective of the nature of how they respond to an injured youth athlete. MAJ believes the intent of this bill, and hearing from the sponsor earlier, is to ensure that parents are well educated on the risks of brain injury and youth-related illness. Accordingly, MAJ proposes striking the words liability disclaimer or waiver on page 5, line 17, and replacing those words with the word notice. I think this change will ensure that parents are notified of the risks while also maintaining level playing field of liability and recovery. Thank you very much for allowing me to testify. I'm happy to take any questions.
Thank you. The Vice Chair has a question. Vice Chair, do you have a question? Do you have a question? Your hand's up. No? Okay, I don't know if you can hear me. Delegate Ebersol.
Yes, I like the provision that a student can't return to sporting unless they've been cleared to go to academics. Won't there be times of the year when a sporting event will occur and there is no academic setting for them to return to? If they're playing in the summer or during break or something like that, that standard might be difficult to meet in that case. Has that been considered?
Yeah, so the amendment, the interlineated amendment takes that out because that was a concern. It seemed to be confusing, and the goal, as I stated, is really to just make sure that the practitioner, the physician, nurse practitioner, whoever who is clearing is not going to say, well, we want you not to be screen time for more than 2 hours, but you're okay to go back and do cheering, right? But it was pointed out that they're probably going to already take that into account. So we did ask that be amended out. Thank you.
So what does something replace that standard for you then?
No, we just left it as, what is currently in law with respect to return to play, and assume that the medical people giving that clearance understand what that should entail.
Thank you. Thank you, Madam Chair.
Are there any other questions? Okay, seeing none, that concludes the testimony on House Bill 435. Thank you. House Bill 468, Delegate Ivy, and then there's one witness following you. So whenever you are ready, Delegate Ivy.
Thank you, Madam Chair, Mr. Vice Chair, members of the Ways and Means Committee. It's a pleasure to present House Bill 468. For the record, Delegate Julian Ivy, District 47A. This is my third time introducing this legislation. Current state law provides protections for whistleblowers who are public school employees. It also already provides the ability to take civil action against their local public school system. However, and really this is the whole point of the legislation, any administrative remedies must be exhausted before they're able to do so. And so this language it's broad, very vague. We've been working on ways to really tighten it up. And so in combination with the current 6-month time frame that whistleblowers have to exhaust these administrative remedies, there have been complaints and concerns of school systems slowing down the process so that it expires the 6-month time frame to take civil action. In its current form, House Bill 468 repeals the prerequisite that a public school employee whistleblower must exhaust these administrative remedies before instituting civil action against a public school employer. The legislation also requires public school employers to provide an administrative remedial process and complete the process within 30 days of the complaint being filed. The legislation also extends from 6 months to 9 months, the limitation for when civil actions can be brought. So this is in line with legislation that we've passed in this committee several years ago, looking to make a reform to make it provide better protection for these whistleblowers, to speed up the process and to ensure that their civil action suits aren't being taken off the table due to really them just being waited out. So I ask for a favorable report on House Bill 468, and I look forward to your questions and working on this bill. Thank you.
Thank you. Next, John Willems, please, for 2 minutes.
Madam Chair, members of the committee, John Willems representing the Maryland Association of Boards of Education, testifying in opposition to House Bill 468. We certainly appreciate the intent of the bill insofar as it is to provide some guardrails and clear definitions around what the administrative process would be. But the bill removes the requirement that the employee would actually avail themselves of those administrative processes. And so it just eliminates any requirement that they exhaust the administrative process before going to court. It does tell us what kind of process to put in place, to be clear. So there might be a path to clarifying that the employee is still and all required to participate in that process within some timelines and guardrails, but that's not what this bill does by bracketing out and removing any requirement that they exhaust their administrative remedies before essentially seeing us in court. And so we certainly support the now fairly long-standing School Employee Whistleblower Protection Act as it's been in place now for a number of years, and we've consistently opposed this provision to remove the requirement that employees participate in the administrative hearing process, complaint process within the local school system before going to court. Thank you.
Thank you. Are there any questions for the bill sponsor or Mr. Willems? Okay, seeing none, that concludes the testimony on House Bill 468. Moving on to House Bill 314, Delegate Novotny, and then there are 2 witnesses signed up. Whenever you're ready, Delegate Novotny.
Thank you, Madam Chairwoman Atterbury, and good afternoon, members of the Ways and Means Committee. My name is Delegate Reed Novotny, representing Howard and Carroll counties. The bill I propose is a good government anti-gridlock bill. From the Supreme Court and their 9 members to our legislature with 141 members, most governing bodies around the world have an odd number of eligible voters. If they are set up with an even number, like our US Senate, there is a tiebreaker to ensure progress is made by a simple majority vote. Most governing bodies in our state have an odd number of eligible voters, with the outlier of being the 7 counties who have an even number of members eligible to vote on their Board of Education. I personally want my county's Board of Education to be as productive as possible and as representative of the parents as possible, but with an even number of voters eligible, they are not. Let's use my home county, Howard, as an example of how having an even number of eligible voters is a bad idea. The current Howard County Public School rule states that a 5-3 majority is needed to pass a motion that has 8 eligible voters voting. In contrast, if there was an odd number, like 7 eligible, a simple majority of 4-3 is required for a motion to pass. In the case of Howard County School Board, there's a 27% chance of a tie in our school board. And I want to move that number to 0 by making sure we have an odd number of voters eligible. Having the ability to tie slows down our innovative proposals and reduces the ability of our school board to represent all of us in the best interest of educating our children. This proposal gives the power to appoint or elect an odd number of eligible voters to the counties where I believe they will make the best decision for the people they represent. I want to thank you for your time and ask for a favorable report. Thank you, Madam Chair.
Thank you. John Willems, please, for 2 minutes.
Madam Chair, members of the committee, John Willems, representing the Maryland Association of Boards of Education, testifying today in opposition to House Bill 314. Quite simply, we support maintaining the current process of establishing board governance rules and responsibilities and parameters, membership compensation, et cetera, in each distinct section of the education article, sections that have been developed through the local courtesy and ideally collaborative process. There are certainly exceptions to that, and while we don't typically weigh in on local bills, will at the request of a local board, if we feel that a local bill establishes a negative statewide precedent or raises other concerns, our legislative committee will at times weigh in on local bills, but it's quite rare. It's quite the exception. And so we support that process. We understand that student members and their partial voting rights, substantial voting rights, have complicated issues with regard to boards that have odd numbers of members, but the student member, by having substantial voting rights, creates an even number. This bill wouldn't necessarily cure that, though, where there are instances where the student member may be able to vote on some matters and not on others. And the concern with inviting in an undescribed or undefined outside party to break the tie is of grave concern. And so for the reasons favoring the local board governance development process and the concern about that outside party, we request an unfavorable report on this bill. Thank you.
Thank you. Is Joel Hurwitz here? I didn't think I saw him, but Joel Hurwitz, are you present?
I'm here, Chair Atterbury.
Oh, okay, there you are. Go ahead, please, for 2 minutes.
Good afternoon, Madam Chair, members of the committee. I'm Joel Hurwitz, resident of Howard County. Continue with what Mr. Willems said from May. Which one of you is holding lucky number 314? Well, today your chief of staff is now a member of the committee. Or who is the staff for monitoring the Zoom rooms? Join the committee. And who was the first person to testify today? You're now a member of the Ways and Means. Does any of that make sense? Well, that is analogous to what 314 requires. The Board of Ed shall find an additional member by whatever means they determine. As the fiscal note says, this could be an extra paid member who sits essentially waiting to be called off the bench. As the sponsor said and wrote to my post on Facebook, it says it's a good government bill. The intent is to professionalize the Board of Ed and give them flexibility to add, if they wish, another voting member, which could be a student, an elected Board of Ed member, or another member eligible to be on the Board of Ed. Really, professionalizing the Board of Ed would be by having a member of the day, an extra student member. Have they complied with the conflict of interest rules? Have they been sworn in? The fiscal note says the county board may select a non-board member to vote on the matter. Could this be a teacher, employee, administrator, or even the superintendent? The bill does say, notwithstanding any other provision of law. As the sponsor said, he's concerned about other organizations, bodies in the United States, and he couldn't find any examples with even numbers. Well, in a matter of minutes, I did. The website and the reports of the National Conference of State Legislatures and an academic study that says, quote, assemblies with an even number of members are fairly common. And number of these states, such as Virginia, do not have clear tiebreakers. They have to come up with a power sharing agreement. And the issue in Howard County is just wrong. The state law clearly provides that you need 5 votes if a student member can vote, or 4 if they can't. You don't get a tie, you don't get enough members. And this is reflected in the last month, the series of votes by the board. They had to go through this with a member absent, and when the student member abstaining, they had to keep going through a series of motions until they couldn't come to a resolution on expressing
Joel, can you wrap up, please?
Yes, opinion on a local county bill, and they took 3 votes to have to come to their redistricting because they had to work through their till they could get 6 votes. So for these reasons, please give an unfavorable report on this bill.
Thank you. And Delegate Ebersol.
Thank you, Madam Chair. I think it's a question for the sponsor. It's a little, the paragraph on breaking the tie, as it were, it says the the board, I have to read this. The county board may select an individual to meet the requirement under subsection A. Does that mean they're going to select someone not to vote, or they're going to add someone to the voting member of the board, in your opinion? It's not clear.
Delegate, awesome question. And I really am not super happy with the clarity in that paragraph. The intent that I passed to the bill sponsors, and again, I was going to address this with the first testimony also, is my intent was not to get some outsider, some random person, maybe someone who is brought in for one vote. It is just the eligibility that is currently defined. So if, for example, in Howard County, if they decided to appoint, because the way we have it, we have an appointed school board member. If they decided that that number would be 2 to make it an odd number, that's currently how they do it. And it wasn't for individual votes, it's eligible to vote. And I didn't like the clarity, so I appreciate you bringing that up. But it is a long term, and that's why I actually had the date start in 2025 to actually allow people to, if they wanted to elect, say, 8 members from the populace and have 1 student member still elected, they could go through the election process. It was not to get another person that is not currently either elected or appointed, depending on how the school boards do it, to be entered into this process. So I apologize if it was unclear, and the 2 testimonies we heard, I didn't quite get my understanding because it probably was a little unclear, but thank you.
Your answer was still unclear to me. Are in a vote where there's going to be a tie, are you adding someone to vote, or are you subtracting one of the board members from the vote? Just which way are you going there?
So it has nothing to do with an individual vote. It has to do with the eligibility to vote. So if you permanently have 7 members and one guy is not there, one guy or gal is not there, doesn't change what I'm talking about. If it's to make the board an odd number, that's it.
So there would be an additional person,
or 1 less. It's an odd number. It's
all right.
Not,
I'm
not defining that.
One more logistic question.
Sure.
What if how's that person selected?
However, they are currently selected.
So what if there's a tie on that vote?
Explain this to me again. What if there's a tie?
So you have 8 members of the board, and they're going to designate someone to vote, or designate one of their members not to vote, it sounds to me. How do they select that person? I would think the way they would do it is they would vote.
Delegate, I think
we're still have a tie there.
Delegate, I think we're still talking past each other. It's not the individual votes. So imagine that we are electing, and I apologize if it is not written clearly in the draft, but we are electing a new school board in 2022 or new members. Before 2025, they would have to have permanently an odd, a structure where it's odd. That's it. It's not an individual vote. It's not the school board saying, I want an additional person on this. It would be however they elect or appoint, they would go through that process to make sure that there's 9.
It says the county board may select an individual. So I don't know how the county board that's already there would do that in that situation, but clearly the language needs a little tightening up.
I appreciate the feedback, Delegate, and I agree with you, actually. I agree that it's not very clear in that aspect.
Thank you.
Thank you. Any other questions on House Bill 314? Seeing none, that concludes the public hearing for House Bill 314. Thank you, Delegate. We're going to move on to Delegate Ivy's bill, House Bill 467.
Well, thank you, Mr. Chairman. For the record, Delegate Julian Ivy here presenting House Bill 467. This piece of legislation allows for an individual to be eligible for a certificate to teach students in a public Montessori school if the individual already holds a valid credential from a specified Montessori teacher preparation program. For example, the American Montessori Society, the Association Montessori International, a program accredited by the Montessori Accreditation Council. Also, they need to have a bachelor's degree in any field, and the State Board of Elections may require an individual to successfully pass an exam that they would create, and an individual who got their certification in this manner would not be able to teach in non-Montessori public school settings without meeting all the other requirements relating to certification of public school teachers. So while we have, teacher shortage across the state and the country, we have to find ways to let teachers teach. It really is important throughout this time. We do have a couple other pieces of legislation coming surrounding this issue as well. I'd like to highlight the support of this legislation by my CEO of my public school system, Dr. Monica Goldson. She provided written testimony, and there are several educators and representatives from various Montessori societies that are here to speak. I'm asking for a favorable report on House Bill 467. Thank you, Mr. Chair.
Thank you, Delegate. We're going to go to Marilyn Horan for a 2-minute testimony. Give them another second. If not, then we'll go to Kavita Mehta.
Yes, thank you, Vice Chair.
Go ahead, 2 minutes.
Thank you, Vice Chair, and members of the Ways and Means Committee. Thank you also to Delegate Ivy for introducing this very important bill. I am here today to testify in support of HB 467. My name is Kavita Mehta, and I have been a Montessori student, a Montessori teacher, and a Montessori parent. In 2017, I opened Northcrest Montessori in Howard County. I am the chair of the board of directors of the Washington Montessori Institute, the oldest Montessori teacher education program in the United States. I also serve on the board of Montessori Schools of Maryland, and I am here today as their representative for our nearly 80 Montessori schools and our nearly 4,000 students. Montessori schools are incredibly valuable for children, and research has shown strong cognitive and social emotional outcomes, as well as executive functioning skills for students who attend public Montessori schools. Montessori education is highly personalized, following each child's needs, and children learn to become creative, innovative, motivated, and persistent in their quest to learn something new. Maryland is fortunate to have 6 public Montessori schools located in Frederick County, Baltimore City, and Prince George's County, and each of these has a long wait list reflecting parent demand. Montessori Schools of Maryland agrees with the state's priorities to have highly qualified teachers in every classroom. For a Montessori classroom, this means a Montessori trained teacher, and this bill will ensure that children in our Montessori schools have teachers who are properly trained for that context. Montessori educators know the tremendous strengths and benefits of a Montessori education, and therefore we want to make it accessible to as many children as we can. Passage of the proposed bill before you will help to advance that goal and ensure that children in Maryland's public Montessori programs are receiving the highest caliber Montessori education possible. I urge the committee to support HB 467, and I sincerely thank you for your time and consideration.
Perfect. Thank you so much for that. Bria Pleasance will be next.
Good afternoon. Can you hear me?
Yes, we can. Go ahead.
Good afternoon, Vice Chair, members of the committee. My name is Bria Pleasant. I am a Prince George's County Public Schools Montessori teacher at the lower elementary level. And I'm here today in support of HB 467. And I'm urging you to do the same. 2 years ago, I sat before this committee as a second-year teacher on the verge of losing my job. After completing an extensive training program at Washington Montessori Institute and receiving a master's degree in Montessori education from Loyola University, Maryland, I was basically told it wasn't enough. My credits did not transfer over. Nothing was recognized in support of my gaining my teaching license. So $5,000+ later, 33 credits later that do not go towards a second master's degree. And I am fully certified in the state of Maryland as a teacher. But what I want to urge you or stress today is that everything that I've learned or reviewed in my certification classes was a repeat of everything that I've learned in my Montessori training, from curriculum development, cross-curricular connections, learning lessons, matching state standards, child development, special education. Everything was a repeat. And I am kind of like a unicorn. I was fortunate enough to do all of these things in the suggested time frame that I was given. I'm not married, I'm not a parent, I'm not caring for other family members at this time. And I had resources available to meet the financial burden of taking on this amount of courses while still upholding a authentic Montessori program in a public school. But that's not everyone's story. I've watched highly qualified individuals leave the classroom because they weren't able to do it for various reasons. This is why I'm urging you to support. That way, Maryland Montessori Public Schools can still have an authentic program that has highly qualified individuals in these positions, and it balances the amount of workload that is on other educators like myself. So I'm not in a position where I'm caring for up to 4 classes at the same time because they do not have a qualified teacher. And that's approximately 90 kids, if you were wondering. So thank you again for your time today. I strongly urge you to support HB 467.
Bria, thank you so much for that. We're going to go back to Marilyn Horan.
Thank you so much, Vice Chair Washington and the committee for giving us the time to an opportunity to talk with you. I am currently the principal at Carroll Creek Montessori Public Charter School in Frederick, Maryland. I'm in my 8th year here, and this is the 3rd round of testifying for this bill and the importance of having certified Montessori educators in our schools. We are currently holding our lottery application process. It closes March 15th, and we have 1,200 applicants as of today for our school. And that is for approximately 50 seats. We have 318 children here. And the importance of Montessori education kind of was brought forth to me again as I was reading about Booker T. Washington. So I think it's very apropos that this is happening during Black History Month. He said that if you're going to make a permanent impression on people, we must teach them something more than mere books, practical knowledge, study actual things. And that's what Montessori brings to children. We had a teacher recently who had a master's degree in biology, but she did not have an education degree. We're able to hire her on a temporary conditional license. So what she did was she went back to school and concurrently worked on a Montessori certification as well as a master's in education. So think about how much time that took from her, away from her family and away from education, rather than if she came to us with a Montessori certification, the children in front of her would have gotten that Montessori education from day one, rather than having to wait till she gets this certification. We have lots of supports for teachers, but if we had that actual day one, I've got the philosophy, I know how to present these materials, it would be so beneficial to our children and having all those experiences that Montessori brings to those. So I urge you to please support this bill 467. We started this well before COVID, and while we hate to blame COVID for anything, we have lost so much time. There are so few teachers that are qualified. And in this time of teacher shortage, this is one way to help bring qualified educators to our children. Thank you again for your time.
Shoot, I was muted. Sorry, guys. Thank you for that. Any questions for the sponsor and the 3 witnesses? Seeing none, that concludes the public hearing for House Bill 467. Now we'll take on House Bill 472. Delegate Lewis.
Thank you, Mr. Chair and committee, for making time for me today. I'm presenting House Bill 472, the Hear Our Voices Act of 2022. We brought this bill before you about 2 years ago, but we ran out of time because of the onset of the pandemic. The Hear Our Voices Act requires the State Board of Education to develop policies and procedures for reporting, administering, investigating, and resolving complaints related to incidents of sexual misconduct and violations of Title IX. It also authorizes a person to be able to bring civil action against a local school system that fails to follow these procedures. These policies and procedures would require the Maryland State Department of Education to develop a database for administrators to upload sexual misconduct claims. The bill would also require a public school to notify the parent or guardian of a student who files a sexual misconduct complaint, collect that data in a yearly report and send it to the board, as well as to do more to spread awareness of the complaint process and how folks can go about filing a complaint. Data from the Department of Education showed a disturbing trend for Maryland. Between the 2015 to 2016 and the 2017 to 2018 school years, we rose from the 6th highest ranking state for sexual assault to the 4th, and from the 4th highest ranking state for attempted rape attempts to the 1st. With this bill, we are taking more proactive steps to protect our students and systematically combat sexual assault in our schools. For these reasons, I urge a favorable report. Thank you, Mr. Chair.
Thank you. Thank you. We have one testimony, or two, we have a few actually. Gia Grimm.
Hello, can you guys hear me?
Yep, we can. Go ahead.
Hi, thank you. Dear Vice Chair and members of the Ways and Means Committee, my name is Gia Grimm, and I am a survivor and child advocate, and I support HB 472. When I was in elementary school, I reported a teacher for inappropriate touching. I reported to another trusted teacher. My trusted teacher took me to the principal's office, and I reported it again to the principal. The administration's solution was to have a meeting between me and the teacher that I had reported. I was walked down to his classroom. I sat in his classroom and listened to him tell me that I had misinterpreted his touch and that he was sorry. My elementary school never told my parents that I had reported a teacher. I was not the only student who was touched by this teacher. However, as we all got older and moved on to middle school and high school, he stayed. He taught countless children and he touched countless children. About 10 years later, in 2015, I ran into the teacher that I had reported. He looked me up and down and said, "Gia Grimm, didn't you turn out pretty?" I stood there frozen. I felt like I was 8 years old again, and I couldn't speak. I had lost my voice. But it's now 2022, and I've reclaimed my voice. The lack of uniformity, transparency, and accountability of current Title IX sexual misconduct procedures and practices in K-12 schools leaves students vulnerable to sexual misconduct by teachers, staff, and administrators. Our students need you, legislators, to provide them with the tools to be able to use their voices. While our past does not define us, it does motivate us. I urge you to give HB 472 a favorable vote and to hear our voices. Thank you.
Thank you. Lisa Jordan.
Thank you, Mr. Vice Chair, Madam Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault, here in strong support of House Bill 472 with friendly amendments. Thank you for hearing this bill again. Thank you, Delegate Lewis, for this bill and your continued support for sexual assault survivors. The Maryland Coalition Against Sexual Assault is the coalition of all of your rape crisis centers across the state of Maryland. We're also home to the Sexual Assault Legal Institute, where we provide direct legal services for survivors across the state of Maryland. When we opened SALI, the Sexual Assault Legal Institute, in 2003, we fully expected to see cases involving college students, but we were shocked, and I remain shocked at the high number of cases we have involving children in K through 12. Before, when you heard this bill, we talked to you about a couple of the cases, and let me remind you of those. One involving a first grader who was repeatedly brought to the boys' bathroom and forced to expose his penis. When his parents told the school about it, under Title IX, that should have triggered an investigation. That should have given that child the right to some protective accommodations to prevent further abuse. And when they requested a transfer, instead of denying the transfer, which is what the school did, they might have allowed that transfer. Another case that we presented to you involved a middle schooler who was raped on campus in the middle of the day. She reported the rape, unlike so many survivors. But instead of supporting her and investigating the case, they suspended her for 10 days, alleging that she had engaged in sexual activity on campus. Under Title IX, again, this would have been investigated and the school would have been forbidden from retaliating against that survivor of sexual assault. The friendly amendments that are proposed are to just allow some very few kids to have someone other than their parents involved in the report. They would have to consult with a counselor first at the school. But imagine, for instance, a gay boy whose father really disapproves of his sexuality. You might want to have that child have the option of reporting to a psychologist or maybe to his aunt.
Hey, Miss Lisa, Ms. Jordan,
Yes.
can you finish your last sentence, please?
Yes, I will. Thank you so much. It's always a pleasure to be out of judiciary and in front of Ways and Means, and we will forgive you for stealing our vice chair there. With those comments, we ask for a favorable report on House Bill 472 with amendments.
Ooh, man, that was a great last comment. Okay, guys, we're going to go to Addie Flynn for the last comment on this bill.
Good afternoon, Vice Chairperson and members of the committee. My name is Addie Flynn. I'm a junior at Mary Edsridge High School, and I'm here to request a favorable review of House Bill 472. For young girls who have been sexually harassed or assaulted in school, it's too late. It's just too late. Even if they seek justice and succeed, and even if they send their abuser away for a long time, it's too late. For them, the pain has already been felt. For them, the trauma has already been experienced. And for them, their lives have already been changed. It's too late. They are now more likely to drop out of school, abuse drugs or alcohol, and suffer from long-term mental health concerns. It is too late for her, but it's not too late for the next victim. According to the Coalition Against Sexual Assault, child abusers have an average of 76 victims. From one victim to the next, offenders are more and more likely to escalate to more serious crimes like rape. And I have seen the need for this bill in my school. When I first heard about this bill, I didn't know what a Title IX coordinator was. And I asked many of my friends if they knew who they would go to if they were harassed or assaulted at school, and not one of them knew. They didn't even know what their first step needed to be. Sexual assault is the most underreported crime in the United States, so we should be making it as easy as possible to report. The standardization of the process of identifying, recording, and managing sexual harassment and assault complaints takes pressure and confusion off of school administrations and protects students. If this bill is implemented in our schools, then we would be committing to creating a culture where abusers can be stopped after victim 1, not victim 9 or 10. By arming school administrators with a standard system to handle reports of harassment and abuse, and by educating students on what to do and where to go, we are potentially saving victims 2 through 76. We simply cannot afford not to implement this bill, or else it will be too late for those girls too. Thank you for your time.
Thank you. Any questions for the bill sponsor and witnesses? I do have a question. I think it's from Lisa, from Ms. Jordan. Can you give me, what are the amendments? You mentioned the amendments. I'm not sure what amendments if you talked about it during your testimony, but can you talk about those a little bit?
Yeah, no, thank you for that question. So there's a concern that if you say to a student, we are definitely going to tell your parents, no matter what, in every single case, that you will actually discourage some students from reporting. Delegate Lewis didn't want to make this kind of unfettered discretion on the part of the student, but say the student has to consult with a school counselor. And then there might be a few cases where you would consult with a responsible professional or adult to notify them about this. And I think the obvious situations also include students who are from different cultures. And we unfortunately sometimes see girls or boys who are sexually assaulted, and then their family views that as really something that they invited. So we want to support those students as well. I believe Delegate Lewis has those amendments. I know his office provided me a copy, and they're also written in my testimony.
Got it. I'll try to find those. I did see that, and that was kind of my question to Delegate Lewis as well about that piece, because just the parental notification, like you said, different cultures, it matters, and also just kids are afraid to tell their parents about certain things or don't have those relationships. Delegate Lewis, I did have a question for you. Can you just tell me how is this different from the current notification system that we have in the school system? I know right now, if you are a teacher has to report if another teacher is sexually harassing a student. There's nothing clear in here that says that this is like for students and how do students respond to it. Can you just, maybe I'm missing it, maybe you can highlight that piece of how this will help and notify students that this is available to them as a tool?
Sure. I mean, the crux of the bill is making sure that our school systems and MSD is putting together a process of making sure students and families know who the Title IX coordinator is, and that if something happens, they can reach out to that individual in order to file a complaint, as opposed to the current process. You can go to a website, you can look on, essentially we're putting a lot of onus on survivors to try to figure out who do they go to help them. And we want to make that easier. And ultimately there are a number of survivors who've asked me because they've gone through this and they helped put together this bill.
Okay, that was my last question, Madam Chair. If you want to take over from here, we're on House Bill 472 right now.
Thank you. Thank you, Mr. Vice Chair.
Yep.
I see Delegate Griffith has his hand up.
Thank you, Madam Chair, and thank you for bringing forth this bill. And plenty about this bill I like, but one comment that I heard that certainly alarmed me with this bill is the comment about not being required to share information with the parent. Certainly, as a parent of kids in school, the school system, they're not the school system's kids, they're my kids. And certainly I trust the school system with the custody of my kids during the day, but everything that happens with my kids in school is my business as their legal guardian and as their parent. And so I'm trying to, and we talked about this in another bill last year, we're certainly concerning if what happens if my child experienced something and they end up committing suicide as a result of whatever happened, and I'm not informed of it, and I didn't have a chance to intervene in the home. I mean, that's pretty horrifying, the prospect of that. Can you talk about that portion of the bill?
Absolutely. I think you're referring to the friendly amendments offered by my good friend Alisa Jordan, and I think the reality is, my good friend Delegate Griffith, is all households are not made the same. In some households, I think there are many parents who would create a warm and welcoming and supportive environment to try to be there for their child, their student. But that's not every household, unfortunately. And I think the concern is, we don't want to essentially tell students that, well, we have to tell your parents, regardless of if we tell your parents, then they're going to think, you invited this and may kick you out, right? Or further traumatize you, to give them some agency and like, well, maybe I don't want to tell my parent, I want to tell my auntie, or I want to tell, my swim coach, right? Who I trust. And I know my parents trust, but I feel more comfortable telling them. Or I can, the guidance counselor recommends another person to get some agency. We talked a lot about this, a whole lot. And I think ultimately we just don't want to risk students not bringing forward their complaints because they're afraid of other stuff at home. But I'd be more than willing to talk to you offline.
Yeah, I think that's super concerning that we would put forth a bill and baked into the cake is, we don't trust parents. And we can't say what parents we don't trust and for what reasons, because that isn't defined. Just if someone arbitrarily feels that this parent doesn't have a right to this information, then we're going to take that away. And so we're taking away parents' rights in this bill. And I think that narrow portion of the bill is a huge mistake. So Thank you.
Well, I'll just clarify too very briefly that it is putting it on the student on who they want to have this information shared with. It's not the school system dictating.
Sure. But even tying back to that is, we've talked about over and over, and Delegate Lewis,
we trust our kids.
Sherry, I voted for many bills about recidivism and, respecting the rights of juveniles because their brains aren't currently fully developed. I think it's 24 years old or 25 years old. We've litigated that significantly in our committee and in the General Assembly. But we're going to give the decision making on a very important matter like this to a child who, as we've all acknowledged, their brains aren't fully developed at this point. So if they can't be held accountable fully for crimes they commit, how can we hold them accountable fully to make these decisions to keep their parents out of this conversation?
Data shows that when people file complaints for sexual misconduct and assault, it's because it happened. Typically, it happened. So we're trusting survivors, but I would happily continue this conversation.
Yeah. And I trust survivors, and I'm not denying what they're going through at all. Just the ability to remove parents from the process. That's my only concern in this whole thing. Thank you very much, Delegate Lewis. I appreciate the bill.
Delegate Rose.
Thank you, Madam Chair. And Delegate Griffith brought up my main issue as well. And just sort of to piggyback, because in reading the fiscal note where it says the local school system can notify, as a parent, I would want to know, and I'm concerned with the process and that, someone outside of the home is making the determination whether or not the parent should be informed based on, their own interpretation. And I would be very concerned that if something happened to my child and some other person is making the determination that, for some reason I'm not to be trusted. We all know dynamics in households, and you've brought up a few of them, and I understand that concern, but that's really a big concern to me in the way this bill is written. So that's my main issue is the parental notification.
I understand. I just delving down, the main thing is making sure that for parents and for students, that even knowing who your Title IX coordinator is that's the core thing, so that people can file complaints, because they're currently, as the data was stated, is going unreported. So many of our students, things are happening to them, and the parents currently aren't able to support them because they just don't know. Right? It gives the opportunity for the students to say, like, look, I want to tell my mommy, I want to tell my daddy, but it doesn't currently limit it, because unfortunately all families aren't even. But I share your concern. I have a baby boy. I'm trying to make sure I raise him in a way that he feels comfortable bringing things to me. But unfortunately, we don't live in a world where everyone can do that.
Delegate Guyton.
Thank you so much, Madam Chair, and thank you so much for bringing this bill. That's a hard question, the one that's going back and forth, and I'm hoping that this question might help clarify it. And this is something for all of you judiciary people, because I don't know the answer. If there is an offense like the ones we're talking about here, and it is reportable, these would all, my understanding, would be reportable offenses if somebody is sexually assaulted in school. What happens in the current judiciary process when there are charges brought against someone? How are the parents brought into that or not brought into that? Does somebody know the answer to that? Because that might just clear this up.
I will kick that over to Lisa Jordan if she's.
Yeah, thank you both for that question. So it's a little bit more complicated than that, because Title IX covers both sexual harassment and sexual assault. Sexual assaults that are against a child or sexual exploitation of a child that are committed by a teacher or a person in authority, those would be reported certainly to Child Protective Services and might also be subject to criminal proceedings. In terms of the student-on-student assaults, it's going to be a little bit more fact-based and depend a little bit more about the ages of the assailants and kind of what's going on. But you're correct that if there is a case involving a criminal charge, parents are generally advised of that. In the Child Protective Services context, eventually they know, but it depends, of course, whether the parents are abusers themselves. I do think that one other nuance to this, though, and I hope this does help clarify, that there's nothing about this amendment that somehow creates confidentiality. The bill itself, as introduced, says you must notify parents when this happens. And all the amendment does is, instead of requiring the school to immediately notify the parents, it says you can notify another adult. And that other adult might tell the parents. It might be that the school then decides to tell the parents. It's that initial, we are reporting, and who do we have to reach out to give that student some sort of adult support. And Delegate Griffith, I wish that every single parent was supportive and would embrace that child and protect them after a sexual assault. But unfortunately, in some cases, that's just not the situation. And I am confident that if we say, you have to tell the parents right away, and we tell students, we're going to tell your mom and dad right away, those students are not going to come forward. And I see my fellow witness who is a student right now has her hand up, and I of course defer to the chair about how to respond to that. But I do think it's important that we hear our students' voices on this.
Thank you, Madam Chair, and thank you, Ms. Jordan, for that. And again, so if there is a criminal case of a serious sexual assault, parents are automatically brought into that. So this bill doesn't change that in any way. It just helps the student deal with whether to self-disclose and maybe a less serious case. Is that accurate?
That's accurate, but it also requires that school takes some steps to protect the child. Sure. Criminal investigations, they take a long time.
Yes.
This is something that would help that student immediately.
Thank you so much.
Are there any other questions? I have a couple questions, and I apologize. I came late. I didn't hear the testimony, but if the speaker calls, you got to go. So I apologize. So I have just a couple questions on just what I've been hearing. So one is specifically to Ms. Jordan. Good to see you. I don't get to see you as much as I normally do in the old committee. So if you could explain to me, like, does federal law not require the schools to have some sort of system in place? Because I thought that it did. And then my other question is, and I understand every household is different, parents are different, but I want to know what's going on with my kids and what's happened. So is there a scenario where there's been an incident in a school and, perhaps there isn't a criminal investigation, or, that doesn't happen right away? What's the time frame for me to be told that the incident has happened if my child, for whatever reason, chooses not to inform me? Luckily, I feel one of my kids would probably choose my mother and not me. I hope my other kids would come to me, but I would at least want to know immediately if something happened. I would want to know. So what's that timeline if my child doesn't decide to tell me what's happened?
So the first question, you were asking about the federal law, and the federal law is Title IX. So Title IX is federal law. You are completely correct that federal law does make these requirements. The difficulty is that our students, faculty, and parents don't know about those federal requirements. And so that's what Delegate Lewis's bill really does, is it makes sure that people know about who is the Title IX coordinator and how do you file this sexual misconduct complaint. Moreover, it also creates a database, so we'll have a better handle in Maryland about what's really going on in our schools. And I think this will also help with some of those issues that I was discussing, some of the cases which you may or may not have been here for, to help make sure that those parents, those students in those cases really would have some support. So this is it's an enhancement and enforcement of the current federal law. Unlike colleges where they have a Title IX coordinator at each school, a lot of times you'll have one Title IX coordinator for, say, the whole school district. And so it's not the same sort of easy access. So that's very important. In terms of your second question, there is no timeline built into this bill about when people would be notified. So there's not a timeline, and perhaps there should be. However, this bill does have the authority for the Department of Education, the State Department of Education, to create rules and regs. And I would anticipate that that's where those rules and regs would be. to say this is how long this would go. I appreciate what you're saying. I do think it's an incredibly difficult issue, and it's especially difficult to talk about allowing an alternative notification with people like yourselves on the committee who are good parents who embrace their children, but that's just not every kid, And so it might be that this process is the student talks to the school counselor, together they make this decision, and maybe they're going to an aunt, and maybe in the course of that, they're also realizing that if that child goes home, the child's going to be abused, and then they are bringing in Child Protective Services. Or maybe the child is going to the aunt, and then together they're going to you or your mom or whoever is going to be involved. So I think it's an unfortunate reality that we need this out, because kids don't always want to talk about sexual assault with their parents. And if you say automatically the parents are going to know, then you're really going to undermine the intent and purpose of the bill.
I see Delegate Feldmark has a question.
Thank you, Madam Chair. My question is for Addie. When we were talking about the parental notification, it looked like you had something you wanted to say, and I just wanted to make sure we got the student perspective on that.
Thank you, Delegate. I want to propose an idea that to get around having to inform your parents if something happens to you, if the student could pick someone on their emergency contact list, which is of course decided by your parents who's on your emergency contact list, but that gets around having to tell your parents directly. I know on my emergency contact list are my grandparents and some very close family friends who those are the people who I would be comfortable going to if it weren't my parents. And that way I feel like at least you're going to someone outside of the school system and someone who your family trusts.
That is an excellent idea, Addie. Thank you. Any other questions? Just scanning. Okay, seeing Delegate Lewis, do you want to say something?
I just want to thank Addie and Gia for sharing their stories. It's really hard for folks here, but thank you, Madam Chair, and the will of the committee. Thank you.
Thank you. And that concludes the testimony on House Bill 472. Moving on to House Bill 352, Delegate Chi, and there's about 5 witnesses after her who have 2 minutes each to testify. So Delegate Chi, whenever you're ready.
Great, thank you. Thank you, Madam Chair, and good afternoon, members of the Ways and Means Committee. I am Delegate Lily Chi, here to present HB 352, which is American Studies and Social Equity Standards Advisory Board. HB 352 would establish the American Studies and Social Equity Advisory Board within the Maryland Department of Education to review and update American Studies standards and policies for greater inclusion and equity in our public education. I know this committee is hearing several bills this session related to school curriculum. An important distinction is that this bill is not a curriculum mandate, nor is it a bill about ethnic studies only. Instead, HB 352 establishes a framework for model policies that counties can adopt for a more inclusive set of curricula to improve our students' baseline cultural literacy. So why is this bill needed? When I first came to America, I was blown away by Americans' hospitality. In fact, in my first letter home, I told my family in Shanghai that Americans are so friendly. They smile to strangers. Indeed, I have developed a deep appreciation for American civility and the overall receptiveness to outsiders, which is what this country is made of. But the events of the last 2 years showed us just how fragile our civility is if we don't work to protect it, just like how fragile our democracy can be. The values that many of us took for granted as synonymous to being American or living in America were challenged by an invisible virus and the aftermath of social divisions and upheavals. Many of us who came after the civil rights movement were shocked at how ready some Americans were to turn on their fellow Americans when things got tough. And it didn't take much to reveal that ugliness. We all went through a lot of soul searching in the past couple of years through anti-Asian bigotry and xenophobia, the Black Lives Matter movement, and other social and political events that revealed a very different America than many of us had come to learn and appreciate. HB 352 started as a desire to see more inclusiveness in our public education for all communities. In the course of our team's research, we reached out not only to the State Board of Education to understand its current framework on American studies generally, but also conducted a survey of what's currently being taught across the county's school systems. To their credit, 14 out of 24 school systems submitted written responses, with many listing in great detail what they are currently teaching. What we learned was that while some counties do a much better job than others in teaching the history and the cultures of different communities, there's great inconsistency and some troubling confusion and a void. For example, some listed the teachings of world history about India and China as Asian American studies. It's obvious that our education and the school systems can use some guidance and resources. After months of deliberation and conversations with different stakeholders and evaluating the different models of other states, we decided that instead of any direct mandate on curriculum, which we are no expert of, what we really need is a systemic approach that assesses what's being taught and developing model policies that counties can adopt to ensure some minimum standards. I am heartened that this bill has received the strong support of many advocacy groups and community leaders that reflect Maryland's beautiful geographic and cultural diversity. Besides MSEA, whose amendment we'll be happy to adopt, we also have ARC Maryland, the Maryland Disabilities Council, the Maryland Student Coalition, as well as the Lower Shore Progressive Caucus, the Salisbury PFLAG, the Montgomery County Progressive Asian American Network, and the many other community leaders that you will hear from. As you will see in some of the submitted testimonies, many Marylanders who grew up in our public school systems did not learn about their own people's history and cultures until college, and wished they had more exposure to other people's experiences and perspectives, and learned about how they are all connected. After all, what is the purpose of education if it was not for a better understanding of ourselves and the world? Census 2020 just reminded us that Maryland is now majority minority. This bill is a timely move to provide guidance, but also allows flexibility across counties and over time. We understand as state legislature, we do not want to be too prescriptive about what schools must teach. So we believe this approach would move us in the right direction. Thank you for your favorable consideration.
Thank you. Next, Jay Guan for 2 minutes, please.
Good afternoon, community members. My name is Jay Guan. I am a resident of Clarksburg and a longtime advocate for immigrant communities of all stripes and also immigrant majority communities. I'm here to express my support for House Bill 0352. Our state is diverse and so is our history. As our state becomes even more diverse, it is of utmost importance for our students to have a fuller account of our history. It is of utmost importance that our students be exposed to the varying experience of their classmates and to understand how these experiences affect our society. It is of utmost importance for all of us to be clear-eyed about who we used to be, who we are, and who we want to be. Currently, our approach to American studies, curriculum standards, and social equity policy is somewhat piecemeal. We rely on individual county school boards to formulate these policies and to obtain relevant curriculums. This resulted in disjointed and at times ineffective implementation. An advisory board that reflects the geographic and demographic makeup of our state can supply the necessary ingredients to help the State Department of Education to standardize these policies, curriculums, and practices. Thus, I implore the committee for a favorable report on this legislation. Thank you.
Thank you. Next, Edward Reed, please, for 2 minutes.
Good afternoon. My name is Ed Reed. I'm a resident of Poolsville. I'm speaking to you from my personal perspective as a dad, educator, and community leader in support of House Bill 352. One evening, my daughter, she looked up at me and asked, "Daddy, what am I?" I looked into her eyes and replied, "Sweetie, you are a strong tree with many roots that stretch across many nations." I went on to tell her about my side of the family, which is predominantly African-American with lineage from Scotland, Ireland, and Native American. I shared her mother's side of the family, which is Iranian and Russian Jewish. Now, why is that important? Our kids want to know not only their roots, but they deserve to learn about various cultures that makes the United States a unique and strong country. Several years ago, during the Obama administration, I joined educational, business, and nonprofit leaders from around the country to participate in a White House convening to discuss college and career readiness. Among the many presenters, what stood out to me the most was the importance of economic impact by ensuring our students develop a high level of diverse cultural competence. When I served as president of the Maryland School Counselor Association, I got a chance to learn about the regional diversity and needs that exist in our great state throughout all of our districts. I often wondered how much was taught to our students about various cultures and contributions made by so many ethnically diverse and social groups that represent our great nation. So the question is, how will our students get the benefit of this knowledge so that they can participate in the global economy at high levels? As the world continues to embrace diversity, it's important that leaders create structures and opportunities for students to get a complete understanding of the various contributions made by so many different groups that unite us as Americans. I believe House Bill 352 provides a framework to bring together a talented team of leaders to ensure all students throughout the state are getting the foundation they need to increase their cultural competence, which can eliminate the pathways to racial biases in curriculums, thus strengthening our students to compete and lead in our global society. Thank you for your time.
Thank you. Ms. Susan Yu, please, for 2 minutes.
Hi, my name is Susan Yu, and I've lived in Maryland for 38 years. I support HB 352 as a Maryland resident. My family's been on American soil for 4 generations. My great-grandfather worked on the railroads, my grandfather in the laundries, and my dad came as a young boy. Dad returned to China in 1939 and ran a trucking station on the Burma Road in support of the Allies. He met Mom, and they returned to the States in 44. I tell you this because out of 4 generations, I was the only one to grow up with a mother and a father. Women weren't allowed in the US due to the Chinese exclusion laws. I had the honor to plan and attend reunions of Chinese American World War II veterans. Their proudest moments were serving in the military, and some were not even citizens. The military gave many the means to escape the confines of Chinatown. It was unlikely for a Chinese person, American or not, to get hired outside of Chinatown. I became interested in World War II. I've been to Normandy, Bastogne, Monte Cassino, and many places where the US fought against fascism. I had 33 years in the federal service working for Walter Reed, Bethesda Naval, and FDA. And why am I telling you this? Because a few days ago, somebody called me Mao on social media. No matter how I am part of this country's fabric, I'm immediately associated with a long dead dictator from another country. I've encountered this kind of harassment many times, and I used to tell myself, it just comes with the territory. Now I tell myself the territory has to change. How do we learn each other's American stories? One way is through education and bills like HB 352. Thank you.
Thank you. Are there any questions? Oh, nope, sorry. John Willems, please, for 2 minutes.
Chair, members of the committee, John Willems, representing the Maryland Association of Boards of Education. We're here today to commend the sponsor for highlighting the issues that would be the subject matter of the advisory board and the concern being the end result being curricular developments and recommendations to the state board that the bill would require that they adopt for the 25-26 school year. This bill's a little different. I know the committee's received a lot of written testimony from me already this session. We're going to general opposition to curricular and instructional and assessment mandates. We appreciate that this bill, in some respects, would put MABE in the driver's seat, if you will, in terms of a leadership role in the advisory board. That said, I want to put in the context of there's a lot in the subject matter to be addressed here, ranging from student discipline to curriculum to professional development.
Mr. Willems, your sound is going in and out and it's staticky, like fuzzy. So we haven't been able to hear you that well.
Is that better?
Yes.
Sorry. Yeah, so just to recap, Madam Chair, members of the committee, you have MABE's written testimony. We are all in on equity. I want to emphasize we have a model equity policy. We encourage boards to utilize an equity lens. The state board actually followed our efforts in that regard. And so we're very supportive of that thrust of this legislation. We do generally and almost always oppose curricular and instructional and assessment mandates. And so that in that context, not on really the subject matter, we are offering testimony in opposition to this bill. And then, as my written testimony indicates, there is going to be a comprehensive content standard and curricular review undertaken aligned with the blueprint. So a lot of curriculum work is going to be ongoing, starting now for the next couple of years as we launch the implementation plans and the realignment of our public education system. And so it's not that this work won't be ongoing, but as the subject matter of one standalone bill with kind of one linear end result in the 2025 school year is a concern to us, again, as a curricular mandate. Thank you.
Thank you. Okay, now I see. I think the other individual is going to testify. I'll just call his name, Vince McAvoy. I think he's stuck in judiciary, testifying on some things. So questions? I see Delegate Plakovich-Carr.
Thank you, Madam Chair. And I think this question is for the sponsor. Thank you, Delegate Chief, for bringing this bill forward. I just wanted to get clarification. I think you mentioned in your testimony that you were supportive of the amendment that MSCA proposed in their written testimony. So basically, that amendment then would not direct or legislate curriculum. Is that correct?
That's correct. They are asking for more flexibility for local counties to adopt the model policies, and I think that would be that's a very reasonable ask. And also to the point that the representative, Mr. Willems from MABE, MABE will have a seat on the advisory board too. So thank you.
Thank you.
Are there any further questions? Okay, seeing none, thank you. That concludes the testimony on House Bill 352. Moving on to House Bill 383, Delegate Corman, how are you? Welcome. Whenever you're ready, you can begin.
Good afternoon, Madam Chair, Mr. Vice Chair, members of the committee. First, let me apologize. I missed a hearing before you yesterday. I had to send my aide, and I appreciate you not hazing him despite the chair. But I apologize that I was stuck in a budget hearing. I know you'll appreciate it was about the Metro Rail system in the DC area, so I could not walk out of that. I'm before you today to present the Young Readers Program Expansion Act, HB 383. Some of you may be familiar with the Imagination Library Program. It's the Dolly Parton program where they partner with local affiliates, nonprofits, to send a book a month to children under 5 who qualify. In the state of Maryland, the governor has been funding this program for Baltimore City through one of his offices for the past few years. This legislation would lock that program in for Baltimore City and then create a new $500,000 fund as a matching grant program for other affiliates around the state to maximize their programs. We have some affiliates who are able to provide books to every student in there, so every young person under 5, 1 book a month in their catchment area. But in many communities of more sizable populations, such as my county, that's been cost prohibitive. This bill would provide some additional funding. It would also encourage local government participation and targeting, in the first instance, disadvantaged zip codes in particular. Obviously, there's a lot of good data about the importance of having books in the home and reading time with your children. Frankly, I don't think the members of this committee struggle for books in the home, but obviously many of our communities and individuals are not in that same position. It's got a pretty positive fiscal note. There is obviously a cost to the program, but there is zero admin cost in the fiscal note, so all of the money is right out the door to provide the service. I want to mention that Nora Briggs from the Dollywood Foundation had to drop off because of a conflict, but you have her written testimony. And I also have an amendment that we sent over to the staff just to make it a little bit more flexible and who can apply for the matching grants if we decide to go forward with this program. So with that, Madam Chair, I hope we can turn to the witnesses, but I hope we'll also pass this legislation to help a really great program that can benefit many of our communities.
If we pass this, do we get to meet Ms. Parton? Because that would be awesome.
That's why I was hoping Ms. Briggs from the Dollywood Foundation would be on the phone, but
that would be super fun.
Yeah.
Okay, everyone else, you have 2 minutes. Ms. Roberta Phillips first, please.
Good afternoon. I'm Roberta Phillips. I'm the CEO of the Prince George's County Memorial Library System, and I am Prince George's proud. Thank you for the opportunity to testify in support of House Bill 383, which will provide essential funding to expand early literacy programs throughout Maryland, including Prince George's County. The program encourages parents and caregivers to talk, sing, share, and play with their very young children to prepare them for school. Having books in the home, as you know, has a strong effect on children's educational attainment, even above and beyond such factors as education level of their parents and parental occupation. Having as few as 20 books still has a significant impact on a young child's success in life. If a parent registers their child shortly after birth, the child can receive up to 60 free books for their home library. Families can bond over sharing books together. Even if a parent or caregiver cannot read, they can still share the pictures, talk about them, and create their own stories, which lead to a child's future success. Over the past 4.5 years, we have reached over 23,000 children under the age of 5, and families have received 480,000 books. 8,583 children have graduated or aged out of the program, and about 2,000 have moved out of the county. We had an incredible video from one of our parents. Her name is Tiffany, a dedicated mother of 2, and she shares that her 2-year-old son started pointing to pictures in the book Truck Stop and identifying the trucks. She started identifying them for him. And since it was a recent development in his interaction with books, she is excited to share with him and use different voices now for the characters, which is building sound awareness, letter recognition, and vocabulary. Currently, we have 13,000 children receiving books on a monthly basis, and our population in Prince George's County continues to grow. With your partnership and investment, the youngest Prince Georgians and Marylanders can get an extra boost through early literacy programs to prepare them for kindergarten and a lifetime of educational achievement. Thank you.
Thank you. Next, Susan Grief.
Great. Thank you, Madam Chair and committee, for this opportunity to speak in favor of 383. As I said, my name is Susan Greif. I'm with Imagination Library of Montgomery County. We are a smaller affiliate. We are 7 years old. We've served over 2,200 children and distributed over 40,000 books in 7 zip codes. Several years ago, a mother sent us a note of thanks. She said that she didn't have much to give, but she wanted to contribute, and she had $2 in that envelope. Her sentiments stick with us because there are undoubtedly so many more families like hers, households with few or no books. This situation has only been exacerbated by the pandemic because many children under 5 without a vaccine have had limited access to libraries or other places with books. And even in the best of times, many families lack the time or financial resources or even transportation to get to libraries. We know that these deficits or the results in deficits in social, emotional, and academic growth, and certainly in kindergarten readiness. These challenges are not going away anytime soon. Dolly Parton's Imagination Library books have arrived without interruption, 1 book every month, right to the child's mailbox in their name, costing just $2.10. In Montgomery County, we enroll about 2% of the children, but there are so many more we want to help. We need your assistance through these additional funds and matching grant program. I'll bet that you can remember your favorite children's book and the time that you spent with your family reading. This is the power of books. And as Dolly tells us, dream more, learn more, care more, and be more. Thank you. Dolly says hello.
Awesome. Tell her we said hi. Thank you very much. And that book behind you, Hair Love, my daughter and I love that book.
It's very popular.
Yeah. Next, Miss Brianna January, please, for 2 minutes.
Thank you, Madam Chair, Vice Chair, esteemed committee members. For the record, my name is Brianna January, and I am representing the Maryland Association of Counties, also known as MACO, in strong support of HB 383. Counties commend the bill sponsor for HB 383, which would provide local governments with an additional resource for their critical work in supporting Maryland's kids as they learn to read and providing greater access to free, high-quality books, as well as while we prepare our kids for K through 12 success. The bill sponsor and the good folks who have gone before me did a great job of explaining just how successful this program is and those like it. So I won't repeat their praises, but I will say that counties welcome the opportunity to partner with the state on this program and others that support our local literacy and K through 12 preparedness efforts. With that, MACO encourages a favorable report from the committee. Thanks.
Thank you. Next, Jennifer Van Kirk, please, for 2 minutes.
Thank you, Madam Chair and members of the committee. My name is Jennifer Van Kirk, and I'm the Executive Director of Bright Minds Foundation, the Howard County Public Schools Education Foundation. I'm here today to express my strong support for House Bill 383, the Young Readers Program Expansion Act, that would expand programs that provide books to young children in partnership with Dolly Parton's Imagination Library. Howard County has roughly 20,000 children between the ages of 0 and 5. And in our county and elsewhere, there remain persistent challenges with children who, regardless of socioeconomic status, are not receiving appropriate reading exposure and support prior to kindergarten. Children's success with school readiness begins at home almost from birth, and delays in the early years of education are very difficult to overcome. Access to books and early reading support has immediate and long-term positive effects on children's language, knowledge, and comprehension skills. As the Howard County affiliate for Imagination Library since 2019, Bright Minds has served almost 1,500 children and distributed over 24,000 books, with a particular focus on engaging higher need and low-income children in our community. The program aligns with state and county goals for early childhood and has far-reaching benefits for participating children, their families, and our county and state. If implemented widely, young reader programs can reduce spending on intervention and remediation, create economic advantages for improved skills for future employment, and decrease the number of students who drop out of school. Student civility and self-discipline will also improve. Our program is supported by a diverse set of donors. However, many more children could benefit from the program, and we would love to offer this program to a larger segment of our county. We hope the county will support this bill. The committee, excuse me. Thank you.
Thank you. And I certainly appreciate, since I represent part of Howard County, you coming to testify. And I also am going to connect with you because I have a ton of books. I'm like, where should I donate them to as my kids fly through these books? So this is good. Last, Nora Briggs, please, for 2 minutes.
I'm sure she had to drop off.
Oh, you did say that.
Yeah, sorry about that.
Okay, I apologize. You said that. Okay, are there any questions for the delegate or any of his panel? Other than when are we meeting, Dolly? Okay, thank you all for coming today. And that concludes the testimony on House Bill 383. Next, House Bill 376, Delegate Guyton. And there are 6 witnesses who will have 2 minutes each to testify. So whenever you're ready, Delegate.
Thank you so much, Madam Chair, members of the Ways and Means Committee. For the record, I'm Delegate Michelle Guyton, serving District 42B in Baltimore County. And I'm here today to gift you all with a really fun and exciting bill. I'm here to request your consideration of House Bill 376, which is the Outdoor Preschool Licensing Pilot Program. This bill allows MSDE, Office of Child Care, to adapt regulations to license forest and preschool programs. In addition, the MSDA will collect data and report findings of this initial licensing phase to evaluate the program and determine whether to expand it. So the purpose of this pilot program is both to increase access to affordable, high-quality early learning programs and to extend the benefits of nature-based learning to families who prefer that choice. Priority for participation in this pilot will be given to existing programs in areas where there are limited early childcare options, and they should also include urban, suburban, and rural areas. The benefits of a nature-based educational model is well documented, and these programs already exist in Maryland. There are close to 60 programs listed on the Natural Start Alliance website. I had a wonderful day at a program in my own district, and I recommend that you all do the same, because you're not going to just see kids running around in the woods. You will observe joyful children engaging in really creative educational curriculum with certified teachers. So these nature-based programs, however, are limited in their hours of operation and in the numbers and diversity of the families that they can serve, because they can't be licensed under current MSDE regulations. They can't accept scholarships for low-income families or provide special education services to kids who need them. So representatives of this emerging and promising sector of our Early Childhood Education Committee are here asking for the opportunity to be licensed, to be elevated, and to be held to similar high standards as other licensed early childhood programs. So I urge a favorable report on House Bill 376 to increase access to high quality, innovative, really cool, fun, data-supported preschool programs in Maryland. And just for your information, I want to bring your attention to the wide support for this bill from almost all of our districts. We've received letters of testimony from constituents from most Maryland counties, from the faculty of the Antioch University Nature-Based Early Childhood Graduate Program, so that's a thing, from the directors of both elementary schools and Judy centers. We have letters from the Chesapeake Bay Foundation, Blue Water Baltimore, and even the National Wildlife Federation, which is kind of exciting for one of my bills. So I also want to point out and to thank Baltimore Mayor Brandon Scott for his letter of support. So I respectfully ask for a favorable report on House Bill 376. Thank you.
Thank you. Next, Victoria Bruce-Farrow for 2 minutes, please. Or Rose. It says Rose.
Oh, yes. Thank you so much, Chairwoman. And hello, good afternoon to the Ways and Means Committee. It's an honor to be here. My name is Dr. Victoria Rose Bruce-Farrow, and I'm an environmental educator and research scientist living in Baltimore City. As someone who has studied the effects of early childhood environmental education for the last 11 years, I am here in support of HB 376. My primary interest in this bill is twofold. First, for what you heard from Delegate Guyton about increasing accessibility of these programs for children and families who would stand to benefit the most from this type of early childhood education strategy. 5 years ago, in 2017, the North American Association of Environmental Education released a report that verified what a lot of nature-based early childhood educators could anecdotally support, and that is that the racial demographic of children enrolled in these programs coming from racially minoritized groups is less than 20%. So my interest in having the bill pass is a lot to do with allowing the programs and the families to attain the resources that they need from city government or government in general, and namely the financial resources such as school vouchers. The data that would be collected and gathered during the pilot would provide a realistic picture of the unique modifications that are needed to include these programs in a professional licensing process. And I hope that the committee will support HB 376 because this pilot would allow us to get started in moving the needle a little bit closer to an equitable, sustainable approach to early childhood education.
Thank you. Thank you. Next, Katie Rooney, please, for 2 minutes.
Good afternoon and thank you. My name is Katie Rooney and I'm the Director of Early Childhood Education at Irvine Nature Center in Owings Mills. That also includes our licensed nature preschool program. I urge you to give this bill a favorable review and thus increase access to high quality childcare and learning experiences that nurture the whole child. Having spent the last 13 and a half years in early childhood education, with all of them but 4 of them in nature-based programs, I can easily rattle off the benefits of outdoor learning for young children. Those benefits are listed in my written testimony. But today I'd like to focus instead on painting a picture of real children that have benefited from programs like this. I like to think about the child who needs to move and whose voice is bombastic and pitched. Inside, he would be labeled as challenging, disruptive, or worse. Outside, he climbs and he runs freely, and that boisterous voice is the leading cry that organizes his peers in games and cooperative work. I think of the child with a congenital muscular condition who has difficulty with walking over curbs, up a step stool, or down a hill. Outside, her days are filled with therapy as she chases after her friends over uneven terrain and scales mulch piles. She has ample opportunities to grow stronger and more confident every day. I think of the child whose father unexpectedly died. Outside, he is able to have space to grieve, and when it becomes too much, he's able to push away his pain with stumps, splash in the muddle to see that, in a muddy puddle to see that he does indeed still have some sense of control and power. And he is able to witness that as the seasons change and the weather changes, that no time of darkness stays forever, and that storms pass and the sun does eventually return. I think of the child learning English. Their family recently immigrated. She's reserved and unsure how to communicate, but outside, the language of play is so universal, she can jump right in and play. I also think of the children that aren't regular students of mine, but instead come to join us for monthly trips and carry homelessness, food insecurity, and trauma on their backs. Their teachers have often said to me that they never get to do this and really play and be kids. So for these students and for all children in Maryland, I encourage you to give this bill a favorable review and to increase access to high quality care, provide more options, and ensure a brighter Maryland future.
Thank you. Monica French, please, for 2 minutes.
Hey there, can you see me?
No, we did. You just, there you go.
There we go. Hello. My name is Monica French. I am proudly born and raised in Silverside in Baltimore City. I am a mom to 2 young children. I'm a passionate early childhood educator. I have 15 years of experience working as a teacher trainer, and a preschool director, half of which was spent in traditional school settings and the other half was in outdoor school settings. My current role is with Baltimore City Recreation and Parks, who I'm honored to be representing today, as the director of the Forest Preschool at Carrie Murray Nature Center, in support of Bill HB 336. This very important legislation aligns with the city's mission to create a healthy and green Baltimore. Every day, we witness significant positive effects of outdoor preschool experiences in the children we serve. Free, unstructured, natural play is of high importance because it is a continuous process of learning. A study by the North American Association for Environmental Education shows that children in forest preschools are well prepared for kindergarten. Individual learning processes are enhanced and gained abilities can be transferred to the classroom. Nature-based preschools foster the skills and values that lead to environmental literacy, which supports goals of the K-12 environmental literacy standards required for graduation in Maryland. The majority of outdoor preschool programs are found in upper middle class, suburban neighborhoods, or rural areas. Unfortunately, children from low-income communities or urban areas usually don't have those options. The Forest Preschool at Carrie Murray Nature Center is incredibly lucky to play, explore, and learn under the healthy forest canopy of Gwynns Falls Leakin Park. Yet, we are one preschool in one Baltimore City park. Our forest preschool program currently has a wait list of over 100 families. These families come from all over the city, and they're a reminder of all those who could benefit from forest preschools in their communities. With all of Baltimore's beautiful parks, that is an exorbitant amount of potential. Outdoor preschools promote the mission of the 3 guiding pillars of Baltimore City Recreation and Park: healthy recreation, conservation, and social equity. Carrie Murray Nature Center, its staff and teachers strongly believe that increasing the opportunities for children to learn outdoors will benefit the city and the state of Maryland. Thank you.
Thank you. Rebecca Morris, please, for 2 minutes.
Thank you for the opportunity to speak in support of this bill. My name is Rebecca Morris, and I'm the mother of Peter. He was a student at the Notchcliffe Forest Preschool in Glenarm, Maryland, one morning each week last school year. Peter has cerebral palsy. He uses leg braces and a walker and has a variety of language and communication delays. Peter is now 6, and while he has participated in a variety of high-quality educational and therapeutic programs, they have mostly been indoors and highly structured around goals and objectives. So when I learned of the outdoor preschool at Notchcliffe, I wanted my son to have the opportunity to learn and play in an educational setting that was completely different from any he'd ever experienced, a program that was structured but flexible and focused on exploration and nature connection. Peter requires a one-on-one adult assistant, and we were fortunate that I could provide that for him. Without my physical support, many parts of the program would have been inaccessible to him. Through the Notchcliffe program, I saw Peter grow to love using his walker to travel the forest trails, to play in the mud kitchen with classmates, and to enjoy puppet shows and puzzles with outdoor themes. Peter gained feelings of confidence and independence and a sense of self-direction over his learning, which he has rarely ever had the opportunity to feel. The program provided a safe and supportive outdoor learning environment that allowed him to take risks, explore, and experience natural consequences. For example, when you don't wear your raincoat, you get wet. Peter's participation was only possible because I could attend the program with him, which is something that many families of students with special needs simply are not able to do, making the outdoor preschool experience inaccessible to so many. Licensing outdoor preschools is the way to make them accessible for all. I've seen the power of outdoor early childhood education for my son, and I know it has the potential to provide enormous benefit for so many other students with special needs. Thank you.
Thank you. Atia Wells, please, for 2 minutes.
Hello, thank you. Thank you, members of the committee, for this opportunity to testify in strong support of HB 376. My name is Atia Wells. I am a pediatric nurse and the founder and executive director of Backyard Base Camp, an urban environmental education organization based in Baltimore City. I fell in love with nature about 10 years ago when I went on my first hike. I made my first mud pie when I was 25. And after learning more about the natural world, I recall feeling both excitement at learning what lives around me, coupled with a deep sense of grief that I did not have these experiences growing up because my family didn't have discretionary income for these types of programs and activities. I now have 2 children. They're 9 and 5 now. And we could also not afford those opportunities for them. However, with a program that we started on our urban farm, we were able to provide a summer camp for children in Baltimore City last year. It was completely outdoor, and although we only had 8 slots, 40 families wanted to register in the first 24 hours. So we do know there is a need for programs like these. Research has also shown that outdoor education has led to better social, emotional, and academic outcomes for children. Please vote favorably on Bill HB 376 to establish an outdoor preschool licensing program and keep Maryland ahead of the environmental education sector. Thank you.
Thank you. Next, Monica Lubinsky, please.
Hi, thank you. And thank you to this committee and to all of the delegates who are already sponsoring the bill. My name is Monica Weedle-Lubinsky, and I am the founding executive director of the Eastern Region Association of Forest and Nature Schools. We provide support and professional development for our teachers all over the country who engage in this type of outdoor learning. Particularly with the pandemic, it's really exploded with a need for children to benefit from all of the many social, emotional, cognitive, and certainly mental health benefits of being outdoors. I'm here to encourage you to vote for this bill. It may be unclear as to why an outdoor preschool may need to be licensed, or even what that actually is. An outdoor preschool is a preschool program that is fully immersive in the outdoors. They can take place in parks, on a farm, it could be in the woods, it could be in the meadow. Maryland, we're fortunate that we have many different kinds of habitats where this might occur. Outdoor preschools do not want an indoor classroom space. They do not need or use an indoor classroom space. The learning is really about nature connection and a focus in those spaces. Yet, the teachers are still trained and hold credentials so that they understand developmentally appropriate practices. They still are trained in first aid and CPR. They still have important health and safety protocols in place, as well as documenting student learning and aligning with developmentally appropriate curriculum. So these are, in fact, preschool programs. They look and feel, in terms of the relationships with families and teachers and students, they look and feel very much like a typical childcare center or preschool, except there's not an indoor classroom. The learning happens outside. As many of the other witnesses have testified, outdoor preschool licensing is important. First and foremost, this issue of equity comes to mind. Children whose families need to use a child care subsidy cannot use them in these unlicensed programs. They can't. They don't get to come. And that means that the small programs that do operate have to offer a very short day, which again limits who can attend, because only families that need short amounts of care or activity for enrichment can attend. And it also means that those small programs are forced to choose between setting aside money in their own budgets to make sure that there's access for those families, or pay their teachers a more livable wage. So it's a horrible position for these programs to be in.
I'm going to have to ask you to wrap up your testimony.
Sure. I also just want to point out that we hold a high bar for the licensing standards that the Office of Child Care has in place. And we want to be sure that teachers are equipped and can conduct these programs in a really safe manner. So again, we asked for your support of HB 376. There's a great deal more information in my written testimony if you're looking for some more background information, but thank you.
Thank you. Our first question is from Delegate Ebersol.
Thank you, Madam Chair. Very sorry about that. I was actually looking at the bill. Good idea. I've actually been to an outdoor preschool and found it pretty exciting how they had the full bodysuits for the kids. When it was really, really cold, they were still staying outside. So I'm very excited by the concept. There is some language in the bill that has me a little concerned. There are two references to State Department of Education being able to waive or adapt. Adapt is one thing, but waive existing childcare licensing requirements is pretty broad. I think probably, I hope the sponsor would agree, we need to tighten that language down. Also, saying they can adapt the Excel program as necessary. I think probably some guardrails. I would ask if the sponsor thinks that's a smart thing for us to do. I'm also curious, so I'll ask it all at once and you can kind of go into it all of it. At the end, we say that there's very specific, the Eastern Region Association of Forest and Nature Schools and the Outdoor Preschool Licensing and Advisory Team are cited as the department shall use them. So I don't know much about them. One I could find online and one I couldn't. So I'd be curious why they were selected and who they are. Also, and about the language, MSDE, adapting and waiving rules.
Mm-hmm. Yeah, thank you so much for that question, Delegate Ebersol. I'm glad you think this is a good idea. It's a very exciting program. I took some notes. You had a couple of questions there, and I did neglect to mention, thank you for bringing it up, that in fact, there is one amendment that we've introduced to the bill. It's purely a technical amendment that took out an extra word, and, which should not have been in the bill. And then I am considering favorable. It's still an amendment.
What's the word? Can you tell me where that is?
It's AND on page 4 in line 11. It was just an unnecessary typo. It doesn't change anything about the bill. But I'm also certainly willing to, and I've told Christina push this myself, take the word waive out of the bill as a friendly amendment.
Thank you.
Your other questions, let me see.
Just how were the organizations
Oh, sure.
that are cited, how were they selected? Who was MSCE interested in them, or, you know?
I think I'll throw that one to Monica.
Thank you. Yes, we've convened an outdoor preschool advisory team about 1.5 years ago. A number of us working all over the state, stakeholders, everyone from the Maryland Association for Environmental Education to some folks who we've been working with through the Project Green Classrooms initiative, a number of stakeholders across Maryland who are outdoor educators and environmental educators, researchers, professors, make up this outdoor preschool advisory team. I am the co-chair of that association. I should also mention that in addition to organizations, there are also a number of family child care providers represented. So the group is really a large group of stakeholders who feel strongly that in order for this to happen successfully, we want to be sure we know that the Office of Child Care doesn't have a lot, if any, real specific experience on 100% immersive outdoor programs. So in order for a pilot program like this to take place, we feel it's really crucial that that guidance happens hand in hand so that the guidelines make sense to accomplish the nature-based educational components that we're looking for.
Thanks. And I don't want to stretch this out, but I just want to know, those two organizations, the bill says they shall work with them. So has MSD been consulted? Just pretty much yes or no? We worked with them. We're hoping to work with them.
We're hoping to work with them.
Thank you very much.
Are there any further questions? Okay, seeing none, that concludes the testimony on House Bill 376. Calling House Bill 489 and Delegate Acevero, and there are 6 witnesses after who will have 2 minutes to testify. Delegate Acevero.
All right, good afternoon, members of the Ways and Means Committee. Can you all hear me? I just want to make sure.
Yes.
Okay, all right. Thank you, Madam Chair, Mr. Vice Chair, members of the Ways and Means Committee. For the record, Delegate Gabriel Acevero here to testify in support of House Bill 489, the Commission on History, Culture, and Civics in Education. Colleagues, this is really, in my opinion, the unfinished work of the Blueprint for Maryland's Future and the Built to Learn Act, which were 2 serious investments in our public education system that I think will have phenomenal impact for all of our students. But equally as important to where our kids learn and who they learn from is what kind of curriculum they're also learning from. And so what's equally as important is that each and every student in our public school system, really in our state, should see themselves reflected in that curriculum. And what the Commission on History, Culture, and Civics in Education, or House Bill 489, seeks to do is, in essence, bring together the stakeholders from our boards of education to various represented groups to our teachers, et cetera, to ensure that we're not just looking at but updating our public school curriculum and ensuring that whether it's the history of African Americans, Latinx or Hispanic, Asian American and Pacific Islander, women, people with disability, LGBTQ plus folks, civics, ensuring that that is something that is uniformly taught. And this is something that we can really accomplish, particularly as there are several parents who not only would like to see our school not only teach a more accurate account of our history, but for us to also understand civics, how our government works, how our society should work. And I think teachers play that important role in getting that done. So House Bill 489 simply creates that commission, ensures that we are working with state and local board of education. We're getting this accomplished, and we're centering students and ensuring that everyone has a quality education. I will note that there was an amendment that was submitted to HB 489 by the MSEA, which I fully support and endorse. I think what we want ultimately is something that gets at the heart of the issue, and which is culturally responsive pedagogy. It's not just about teaching history, but ensuring that no student leaves an art course without knowing who Frida Kahlo was, no student leaving an integrated science course without knowing people like George Washington Carver, Lewis Latimer, and of course, Marylanders. Not a lot of folks know that a Marylander helped co-found the North Pole, right? And so all of these things are important so that our kids are getting the kind of education that other kids are getting right now. So I asked for a favorable report, and I appreciate folks taking the time. Thank you.
Thank you. Next, Ongisa Ichile Mackenzie. For 2 minutes, please. Okay, I'll move on to the next person and perhaps circle back. Lashana Stitt, please, for 2 minutes. Okay, I'm just going to keep calling here. Allison Lloyd.
Hello, and thank you, Madam Chair and esteemed members of the committee. My name is Allison Lloyd, and I'm speaking on behalf of Free State Justice, Maryland's LGBTQ civil rights advocacy organization. I'm also a doctoral student at the University of Maryland, Baltimore County, working in the Youth Justice Lab, where part of my research focuses on ways to create affirming schools for LGBTQ students, both inside and outside of Maryland. I'm here to share exactly why House Bill 489 would improve learning outcomes and the school climate for LGBTQ students in Maryland. It is without question that students learn best when they feel safe, included, and supported in school. Unfortunately, for many LGBTQ students, this is not always the case. A national survey of 35,000 LGBTQ students found that over 50% of youth reported being bullied on and offline this last year. Another survey of Maryland's LGBTQ students found that 67% of youth experienced harassment and assault, specifically on the basis of their identity. Addressing this issue is critically important, as LGBTQ youth are 4 times more likely to consider suicide than their non-LGBTQ peers. Despite facing hostile school environments where administration may or may not adequately support youth, LGBTQ youth still find ways to cultivate joy and strength. When students were surveyed about where they find this joy, they consistently answered that it made them excited to learn more about LGBTQ history. By establishing the Commission on History, Culture, and Civics and Education, educators would be given the tools to authentically represent LGBTQ history and culture throughout school in Maryland. Creating a more inclusive curriculum has benefits for all students. It creates the opportunity for more friendships, decreases prejudice and increases tolerance, and creates a safer classroom environment by reducing bullying amongst peers. For LGBTQ students specifically, being represented in curriculum through learning more about their own history and culture allows them to imagine a future where they too can make a meaningful impact on the world. As a researcher, queer person, and Howard County Public School alumna, I am confident that establishing this committee would greatly enhance the learning outcomes in students who desperately want to be supported, accepted, and seen in school. It is for these reasons I urge a favorable report of House Bill 489.
Thank you. Next, Ikenna Wusu, please, for 2 minutes.
Good afternoon, Madam Chair and members of the committee. Thank you for considering this important bill. My name is Ikenna Wusu, and I'm an advocate of the Anti-Racist for Maryland Schools Coalition. We strongly support HB 489. It is critically important because Maryland's demographic has seen a drastic change over the past 20 years. And now our public schools population is over 60% students of color. We need the multicultural traditions and experience of students reflected and centered in our curriculum. An inclusive curriculum is imperative for students of color to have a better understanding of their own identity in the society where they have been traditionally seen as other. We have waited too long to take the steps needed to ensure that students of color are seen, have a sense of belonging in our state. An inclusive curriculum helps students develop healthy identity, a sense of belonging, and foster better understanding among students from different backgrounds. Study has shown that these factors affect academic performance and the overall social environment of the schools. When I was a student, topics surrounding Black experience was not comprehensively taught. I had to learn these things on my own, and my knowledge of these topics have really expanded when I entered college. Events such as redlining of Baltimore City, racial discrimination in the GI Bill, and the burning of Black Wall Street are just a few of historical events that were ignored. It's not just tragic events of the past. I remember I didn't learn much about prominent Black figures who were scientists, academics, and inventors who changed the world. Also, the experience and contributions of Latin Americans, Asian Americans, and other minority groups were virtually non-existent in the classroom. It's important for both students of color and white students to know how their ancestors contributed to American innovation and greatness. For this reason, we need an inclusive process for developing a curriculum to reflect all Americans. So I urge the committee to vote favorable on this bill. Thank you.
Thank you. Next, Frank Pantinella for 2 minutes, and I butchered that. I'm sorry.
It's Patinella. Thank you. Thank you. The other two members that you called, Angisa Echele and LaShawn Stitt, they may be back. They were picking their kids up. So we'll see.
Totally understandable. Okay.
Thank you. Good afternoon, Madam Chair and members of the committee. Thank you for this opportunity. My name is Frank Patinella, and I'm a senior education advocate for the ACLU of Maryland and part of the Anti-Racism for Maryland Schools Coalition. We support House Bill 489 with amendments. I understand that legislative leaders don't want to dictate curriculum to MSDE and school districts on curriculum, but this bill doesn't do that. It doesn't force the adoption of new standards. Instead, this bill is a way of saying there's a big gap. We're becoming more and more ethnically diverse, and let's start the conversation. The bill would establish a process to explore vast histories, cultures, world-changing events, good and bad, and innovations and contributions of our diverse American and Maryland communities. Why leave them out? MSDE and school districts will decide if and what to adopt based on the Commission's recommendations. This is also not critical race theory or indoctrination. One prominent African-American educator, leader in our country, Gloria Ladson Billings, recently said this when asked about the 1619 Project and Trump's 1776 report. The smart teacher will share them both and have students do the work that it takes to make sense of these documents. This approach is anti-indoctrination. On a personal note, as a child of immigrant parents, I struggled in school through high school. And I was always in trouble and at least a grade or two behind my classmates. It wasn't tutoring or mental health counseling that helped me get to where I am today. What was transformative for me was being able to gain a broader and healthier perspective on my own ethnic identity and those of my classmates. One amendment we'd like to see has to do with the appointments of the commissioners. We're asking that all the legislative caucuses be given the opportunity to nominate candidates for the governor's appointment. The African American caucus, Latino, Women's, Asian Americans, and Pacific Islanders, and let's not leave out the rural caucuses or caucus. Another change is about the additional qualifications of the commissioners. There should be language that requires high-level credentials and expertise related to the topics in this bill. And we should also make room for students, parents, and community members to participate. To close, I urge your support for this bill with these amendments. Let's not make a $4 billion investment in the blueprint bill without missing this piece of the puzzle to ensure that we are maximizing outcomes by lifting up our diverse histories, lives, and cultures for every student in Maryland. Thank you.
Thank you. Vince McAvoy was signed up unfavorable. I think he's still in judiciary, but I'll just call him to see. Vince McAvoy. Okay, and calling one last time on Gisa Echele McKenzie or LaShawn Stitt. Okay, are there any questions for the delegate or for his panel? Okay, seeing none, thank you. That concludes the testimony on House Bill 489. Next, calling Delegate Boyce, House Bill 384. And she has 12 witnesses who will have 2 minutes each to testify. And Delegate Boyce, whenever you're ready.
Thank you, Madam Chair, and thank you, committee. For the record, I am Regina T. Boyce testifying today on HB 384, Public and Non-Public Schools Bronchial Availability and Use Policy, or a Rescue Inhaler Law. HB 384 requires public schools in the state and authorizes non-public schools to establish a policy to stock inhalers, albuterol, in schools for emergency purposes, a rescue inhaler, requiring select personnel to be trained to administer the inhaler in the absence of a school nurse, and removes personal liability of nursing personnel. According to the Asthma and Allergy Network, 7.6% of Maryland children have been diagnosed with asthma. 56% of children with asthma do not have an asthma plan on file at their school. And it is reported that 19.2% of parents with asthmatic children report that their children miss 1 to 2 days of schools because of their asthma. Asthma is one of the leading causes of school absenteeism in the country alone. Add to those stats the number of individuals who haven't been diagnosed with asthma and the growing shortage of school nurses, we have a risk management dilemma. In the US, asthma is responsible for 10 deaths a day. Given this stat and risk, states are considering stock albuterol rescue inhalers in policy and guidelines. Currently, 14 states, to include Arizona, Arkansas, Georgia, Illinois, Indiana, Kentucky, Missouri, New Hampshire, New Jersey, New Mexico, Ohio, Oklahoma, Utah, and Virginia have stock albuterol laws. And 2 states, New York and Nebraska, have stock albuterol guidelines. At the federal level, Congressman Steny Hoyer introduced and passed H.R. 2468, School-Based Allergies and Asthma Management Act program in December of 2020. The bill amends the Public Health Service Act to increase the preference given in awarding certain allergy and asthma-related grants to states that require certain public schools to have allergy and asthma management programs. This federal act allows states to create and implement programs as needed with financial assistance. What I've learned about asthma is that you cannot diagnose it without first having an incident or an asthma attack. Unfortunately for some, an asthmatic incident or attack is the first and last sign of a respiratory condition. An inhaler is as important and life-saving as an EpiPen or naloxone. It must be available in our schools, and it must be added as a stock item to the life-saving toolbox for our schools and school professionals. And it's for these reasons that I thank you for your time and ask for your consideration of a favorable report.
Thank you, Delegate Boyce. Next, for 2 minutes, please, Sarah Choi.
Good afternoon, Madam Chair, Mr. Vice Chair, and committee members. My name is Sarah Choi, and I'm a pediatric pharmacist at the Johns Hopkins Pediatric Emergency Department. I am testifying today to the safety and efficacy of albuterol inhalers and to the necessity of this legislation. In the event of an asthma attack, inflammation and constriction of the small microscopic airways in the lungs can lead to difficulty breathing, wheezing, and respiratory distress. Albuterol is a medication that works quickly to relax the smooth muscles, and this opens it up, making it easier to breathe. Immediate interventions are necessary in anyone presenting with severe respiratory distress because if untreated, an asthma attack can lead to cardiorespiratory arrest and potentially death. Albuterol is one of the safest medications we use. It has a quick onset of action of less than 5 minutes and has minor adverse effects, including tremor, increased heart rate, and nervousness. The only contraindication to administering albuterol is a previous anaphylactic reaction to albuterol, which is extremely rare. The benefit of administering albuterol in a child presenting with respiratory distress outweighs any potential risk of albuterol, as this can be a matter of life and death. Providing albuterol in a child who presents with respiratory distress but does not have asthma will not cause patient death. It may cause some short-term elevated heart rates, which can last for about 4 hours. On the other hand, administering albuterol in a child who presents with respiratory distress with undiagnosed asthma but actually has asthma will save this child's life. The low risk of increased heart rate is incomparable to saving a child's life. Thankfully, the pediatric emergency department is well equipped with resources for a child to receive the necessary treatments. Although a school environment has minimal resources, the provision to administer albuterol can be life-saving, as the vast majority of children exhibiting respiratory distress at school is due to asthma. The time between when a child shows respiratory distress and to when the child arrives to the hospital are critical moments that must be taken advantage of. Albuterol is a safe, effective, and necessary tool for our children to have access to in schools. Thank you very much.
Thank you very much. Next, Elaine Papp for 2 minutes, please.
Thank you, Chairman Adderby, Vice Chair Washington, and committee members. My name is Elaine Papp. I am a registered nurse with a master's degree. Retired from my full-time job, I worked part-time as a contract school nurse in Baltimore City. I'm here before you to share my story and to advocate for the passage of HB 0384. In 2018, I saved a student's life, but I lost my job. It was a harrowing experience. While working at Vivian T. Thompson Medical Arts Academy, a student experienced a serious asthma flare. Her inhaler was locked in the gym teacher's office. The gym teacher was not in the building. Although 911 was called, they were delayed in responding. While the principals and the teachers frantically tried to find the key to the office, the student lost consciousness, gasping for air at a rate of 70 per minute and a pulse of 124. I was helpless. I knew that after loss of consciousness, the student would have approximately 15 minutes to live if untreated. I was watching the student die. Not knowing when the paramedics would arrive, I gave the unconscious student another student's asthma rescue inhaler. Within a few minutes, the student began breathing normally and regained consciousness. I lost my job because I made a decision to break the rules to save a life. This should not be a decision that anyone should have to make. The rules: never give a student another's medication, and never give a medication if you don't have a doctor's orders in the student health file. As a registered nurse, I had access to the Maryland asthma guidelines. I had Narcan for opiate overdose, and I had EpiPen for allergic reactions. But I did not have an emergency medication to treat the most common life-threatening illness among Maryland's children, asthma. I urge you to report favorably on this important life-saving legislation, and I am available for questions. Thank you.
Next, Charmaine Anderson, how are you for 2 minutes? Oh, you're on mute.
There we go. Thank you, Madam Chairwoman and members of the committee. My name is Charmaine Anderson. I'm the director of a nonprofit dedicated to ending the needless data conditions. I will say I'm also a Maryland resident living with asthma as well as my children. The network supports HB 384, authorizing schools in Maryland to stock albuterol inhalers and for emergency use for any student who's experiencing symptoms of respiratory distress when they don't have their own medication or experience respiratory distress for the first time. With more than 24 million Americans living with asthma, including 6 million children, asthma remains the most chronic, serious condition, and it is the #1 reason many children are absent from school. In Maryland, it's about 1.3 million missed school days annually. The U.S. Department of Education and HHS recommend that schools develop and maintain comprehensive management plans to support children who have asthma while in school. There's also, concerns that unfortunately many of the schools do not maintain such plans and are ill prepared for emergencies. There is a movement across the country, as Delegate Boyce mentioned, where many states are passing laws and guidelines to standardize asthma care. And currently there are at least 16, and counting those who have guidelines in place to prepare for those types of emergencies. At the federal level, as she also mentioned, the School-Based Allergy and Asthma Management Program Act was signed into law in January of 2021. And this encourages schools around the country to put in place comprehensive plans and also increase federal grant preferences for those states under the CDC's National Asthma Control Program. We are working at the federal level to not only include funding for that program, but to allow for states like Maryland to be able to take advantage of the grants. In closing, we are very excited about this bill. We hope that it becomes law, and we thank Delegate Boyce for being a leader in just championing this effort. Thank you.
Thank you. Next, Alex Casper for 2 minutes, please.
Thank you. Thank you, Madam Chair and members of the committee. I'm the Director of Advocacy for the American Lung Association, and we strongly support this bill and applaud Delegate Boyce for her commitment to this issue and keeping children safe in Maryland. You have my written comments, so I will keep these comments brief. In Maryland, just over 129,000 children have asthma. Asthma attacks can occur at any time and often without warning. Children with asthma should always have access to their medication that can quickly reverse the blockages in their lungs. As you heard, this medication is called short-acting bronchodilators. It's easy to administer, inexpensive, and as you heard from our physician experts, very safe. The medication is life-saving in the event of an asthma emergency. Unfortunately, for a variety of reasons, children don't always have access to their medication. And in many cases, like in the school setting, a parent isn't immediately available to provide it. And for many kids, their asthma isn't diagnosed until their first attack happens. The bill before you allows schools to stock low-cost rescue asthma medications and spacers to be used for a child who is in respiratory distress to be used in an emergency. Like Maryland currently allows for epinephrine for allergy attacks. This medication can be easily administered by school staff who are trained to do so. It is critical that additional school staff be trained to recognize respiratory distress and on administration of the medication in the event that there is not a school nurse present. This is something that currently happens with other medications administered in the school setting. The Lung Association strongly believes that allowing schools to stock asthma medications will protect and save our kids in schools. We thank you for the opportunity to provide comments and encourage a favorable report.
Thank you. Next, Sarah Christiana Sandramelli for 2 minutes, please.
Thank you, Madam Chair, Vice Chair Washington, and committee members. My name is Christy Sadramelli. I'm a doctor and a pediatric pulmonologist at Johns Hopkins. I'm testifying in support of HB 384. Asthma is the most common chronic disease in childhood, as you've already heard today, and asthma attacks often occur with little warning. Children really need access to their emergency medications at all times, but up to 80% of children with asthma do not have that at school. This affects children in public school, private school, and in all types of communities. There are many reasons for this. They forgot it, it's expired, there's something wrong with it, it's locked away, they used it all. And very commonly, schools don't have the up-to-date medication and paperwork for that specific child. Currently, schools don't have a lot of options in these situations, and they typically have to call 911. Delaying treatment like that can increase the severity of the asthma attack. Without albuterol, children may suffer from severe asthma attacks and could even die at school. Stock albuterol inhalers are a simple, pragmatic, and low-cost solution. Like EpiPens and Narcan, schools should have it on hand for emergencies. I recommend that you do not limit this legislation to children with a documented diagnosis of asthma. So this will occasionally result in a child without asthma being given albuterol. The downsides of this are minimal, and the risk of side effects is very low. And you may also hear that there are other types of rescue medications we now use in asthma sometimes. But the great news is albuterol is still extremely effective and our first line treatment for emergencies, still in the ER, the hospital, and school. I recently co-authored a policy statement sponsored by the American Thoracic Society, American Lung Association, Allergy and Asthma Network, and the National Association of School Nurses. This group of experts recommended some essential elements for the law, and fortunately, HB 384 contains these elements, and we feel it's a really good proposed law. So now more than ever in the pandemic, the importance of a safe and healthy school environment for young people is clear. And it's really time to add albuterol to the safety plan. And I urge a favorable report for HB 384.
Thank you. Next, Michaela Fritz for 2 minutes, please. We can't hear you. We just saw you, but you disappeared. There you go. You're on mute though.
There you go. We can hear you. Okay, perfect. So my name is Michaela Fritz, and I'm a pediatric nurse practitioner at Johns Hopkins Hospital. Prior to my role as a nurse practitioner at the Johns Hopkins Children's Center, I was a school nurse for Harford County Public School System through December 2021. I am testifying today in support of this bill that could provide emergency albuterol in schools. I had an incident this past fall where a student who was a known asthmatic needed albuterol. He was sent to the health room for a cough and was noted to have bilateral wheezing on exam. There was no question this was an asthma attack. I administered albuterol as prescribed, his cough subsided, and he returned to class. Approximately 4 hours later, he returned with audible wheezing and a violent cough that caused him to vomit continuously. I tried to administer his albuterol inhaler again. However, the pump, which was not empty, stopped working. There seemed to be something wrong with his device. The student had an extra albuterol inhaler in his pocket that his mom had given him that morning. Under the guidelines, I should have confiscated this medication and not allowed him to use it. Instead, he self-administered the albuterol from home, and 911 was called. Fortunately, the medication helped. By the time EMS arrived, his vomiting and wheezing had subsided. This experience had a profound impact on me professionally and personally. I was thankful that his mother had enough foresight to have him carry another albuterol inhaler just in case, even though he wasn't supposed to have it. The implications for what would have happened to the student are vast. What would have helped me in this case would be a law like this one. Not only would I have my own albuterol inhaler supply, I would have had permission to use it in emergency situations. Some nurses in my shoes have done similar things, have lost their jobs. Fortunately, I did not, and medically, I know it was the right thing to do. Now imagine a scenario where the child didn't have a backup inhaler in his pocket. I'm not sure what would have happened, but the situation could have been dire, even life-threatening to the student. And that's actually quite a scary thing to consider for this child who could have had a bad outcome, and for healthcare professionals like myself working in a school environment and knowing they don't have access to a common life-saving drug when we need to use it. I strongly urge you to consider supporting this bill, which will ensure that all children with or without asthma have access to life-saving medication at school. Thank you so much.
Thank you. Karen Babcock, please, for 2 minutes.
Good afternoon. Thank you for hearing us speak, Madam Chair and Committee. My name is Karen Babcock. I'm a respiratory therapist at Johns Hopkins Children's Center. I run the pulmonary function lab associated with the main pediatric pulmonary clinic at our Baltimore location. I also have supervisory duties for other respiratory therapists in our institution. Throughout my career, I have had diverse experiences as a respiratory therapist on the inpatient and outpatient sides of medicine, which include time in the pulmonary function lab and also time in our pediatric ICU. For reactive airways, such as the case of asthma, when the airway reacts and tightens inappropriately to a stimulus, such as virus, allergen, or environmental factors, cigarette smoke, the mainstay of treatment is albuterol. Inhaled albuterol works quickly to relax the muscles around the small airways by stimulating beta receptors of these airways. From a safety and effectiveness perspective, the side effects are very minimal. It's important that legislation is written in a general way for respiratory distress, because the downside to giving albuterol to someone who's not having an asthma issue is negligible. Side effects are minimal, and the risk of not giving this medicine to an asthmatic that it's in distress is very large. Similar to giving an EpiPen for food allergy emergency, giving albuterol promptly could drastically change the trajectory of the child's airway issue. I have personally witnessed albuterol stop or significantly lessen a severe asthma situation many times. Similarly, when an asthmatic needs it, can also without it, the asthma exacerbation can get out of hand very quickly, resulting in severity of the exacerbation, which can lead to an emergency department admission, hospitalization, or even death. As a mother of a school-age child, I also want my child and child's school to have the resources they need to help my child and other children if there were an issue. We as a medical team always try to identify and prevent. This is no exception. Thank you again for the opportunity, and please vote in support of HB 384.
Thank you. Next, Scott Tiffin for 2 minutes. I didn't think I saw him in here, but Scott Tiffin.
Delegate Atterbury, this is Robin Elliott. Scott is over on the other side in the Senate.
Okay, well, you're next. So good to see you, and you can go ahead.
Thank you so much, Robin Elliott. I'm here today on behalf of both the Maryland Nurses Association and the Maryland Association of School Health Nurses in support of the bill with amendments. And following me is Dr. Charlotte Wood, who is going to talk about some of the clinical implications. I'll just briefly say that we have two amendments. They are in your packet. What the amendments do is very much preserve the core of the bill, which is that idea of having stock bronchodilators or asthma inhalers, as we would say in layman's terms. That's very important, and I think everyone has really emphasized that. The other amendments, the first one, makes sure that if there is any medication administration going on by non-clinical personnel, that it is under the control of the school nurse so that we can make sure that it's done safely. The second one relates to what happens when children do not have a diagnosis of asthma or a prescription for a bronchodilator. And you will hear from Dr. Charlotte Wood that the protocol in schools is actually very different for serious patient safety issues. And with that, I thank you for your time and would be happy to work with the committee. And I also thank Delegate Boyce for meeting with us and really diving down into this issue. Thank you very much.
Thank you. And next, Dr. Wood, great to see you.
It's good to see you as well. Always a pleasure. So good afternoon, Madam Chair, Vice Chair Washington. I am Dr. Wood. I have a PhD in education. So because of this type of legislation, I really don't want anyone to presume that I am a physician. But I am a nurse with greater than 30 years of experience as a nurse and have worked in many emergency situations. I've worked at shock trauma, I've worked with the Orioles and the Ravens, and I have worked in multiple ICU areas. I am currently the immediate past president of the Maryland Nurses Association. The Maryland Nurses Association supports the underlying intent of the House Bill 384, since this bill would increase the school's readiness to address the needs of students with asthma. We have actually worked with and met with Delegate Boyce and will continue to do so with her bill, House Bill 384, that has provisions that authorizes the school nurse to identify and train others who are competent in the administration of bronchodilators in an emergency if the student that presents has been diagnosed with asthma. However, there is a small concern that we have with a phrase in the legislation that stipulates, regardless of whether the student has been diagnosed with asthma or reactive airway disease or has a prescription for a bronchodilator. So this child would then be receive a bronchodilator that has not been diagnosed. And I know that everyone heard the delegate very nicely and very appropriately describe a situation where most of the time in the first instance, a child may not present with asthma diagnosed because the first time a child has asthma is when they have an asthma attack. However, if a student does not have a prescription for a bronchodilator and they do not have asthma as a diagnosis, then there is already existing safety protocol that should be used to administer an injectable epinephrine and call 911. You see, a lay person may not be able to distinguish between an asthma attack, an allergic reaction, or anaphylactic shock because they may manifest themselves in very similar ways. What we want to be able to do is understand that a bronchodilator may mask some of those symptoms, leading to a potential fatality. So what we want to do is continue to protect the children. Therefore, we would ask that changing some of this terminology would prevent this very possible negative and fatal outcome. So we believe Adding language that would align the bill with the existing legal requirements for school nurses would ensure ongoing health and safety protocols for our children, which, if the child is undiagnosed, would then receive injectable epinephrine.
Dr. Wood, I'm going to have to ask you to wrap up.
Thank you. We applaud Delegate Boyce, and the M&A will support the bill with the amendments attached to our submitted testimony. Thank you so much for this opportunity. I really appreciate this time.
Thank you. Mr. McAllister.
Can you hear me okay?
Yes.
Okay. Anyway, my name is Jim McAllister. I'm a trial lawyer, but I'm also a parent. And I got to tell you, we adopted a couple of foster kids. And when we first got one of them when she was 6 years old, she had an asthmatic attack. So we always had her carry around an inhaler. And she hasn't had an attack since then. And she's now a freshman at Catonsville. But I will be on the phone tomorrow to Catonsville to find out if they've got an inhaler there. Or otherwise, she's going to start carrying with her. This is eye-opening for me. Anyway, we are in favor of this case as the trial lawyers because it does provide opportunities to save lives. But the only amendment that we would propose is in the closing words of the bill. It says, in the absence of gross negligence. Well, gross negligence means something more than mere negligence. And the current standard, negligence, says it has something called an emergency standard, which is somebody responding to an emergency is held to the reasonable care of somebody under emergency circumstances. So it takes into consideration that these people are responding to an emergency. When you say gross negligence, what you're saying is we're okay with negligence. Well, negligence is not okay. It's not okay to administer medication in a negligent manner. And we don't want schools having to tear their children. While the people that administer this, we're going to be okay with them being negligent. We just won't be okay with them being grossly negligent. So the amendment that we proposed basically says this bill outlines the procedures and practices that are the best practices that the people administering this medicine will have to follow. As long as they follow those instructions and that protocol, then they got nothing to worry about. But limiting the recovery or access to only gross negligence is not good enough. It's not good enough to protect the children. And God help you, you have to sit down with a parent if something goes wrong and say, by the way, we were negligent, but we weren't grossly negligent. So therefore, what happened to your child, we don't have to answer for. So that's the amendment we propose. I salute the delegate as a parent because this has been an eye-opening hearing for me. Thank you.
Thank you. And finally, Laura Stewart, please, for 2 minutes.
Good afternoon. My name is Laura Stewart, and I am representing the statewide PTA organization, Free State PTA, which represents over 34,000 volunteer members and families in over 500 public schools. I'm here today to support HB 0384 with amendments. This bill requires school systems to establish a policy to obtain, administer, and train school nurses and other school personnel to administrate a bronchodilator in emergency situations when a child is in respiratory distress. Considering that 1/4 of high school students in Maryland have reported having asthma and 1/3 of high school students in Baltimore City, as detailed in the Maryland Youth Risk Behavior Survey, we have an obligation to keep these children safe in school settings. I have a child in public school, and before he was officially diagnosed with asthma, when he was 8 years old, he was having symptoms which I did not immediately recognize. I was called by the school and was told that he was not feeling well and that he had a persistent cough. We went to the doctor and his oxygen level was down to 92%. This could have been a dangerous situation. We immediately took stronger steps to control his asthma and brought prescriptions to school. I often think about what could have happened if he had a worse attack that day. They would have had to call for emergency services because he did not have medication at school or an official diagnosis. It could have been too late. This is not an unlikely scenario. Parents don't know what they don't know. If a child goes into an anaphylactic shock, trained professionals can administer epinephrine in order to save that child. This bill similarly expands emergency treatment to children in respiratory distress so that they do not have permanent damage from a lack of oxygen. We do ask that the bill be very clear that this should be used in emergency situations and not for general maintenance, which should be overseen by a doctor. Therefore, Free State PTA asks that HB 384 receive a favorable report with some stronger language about emergency situations. Thank you.
Thank you. Are there any questions? I see Delegate Eversole has had his hand up for quite some time.
Didn't know how many people we had talking there, Madam Chair. Sorry. Probably for the sponsor, but could be for anybody. I read this bill and I don't read that the schools need a policy. I don't read that they have to have. I want to say the term correctly. Let's just say a bronchodilator. We're not requiring them to have them in schools, or we're saying, yeah, you really need that. Has to be part of your policy.
We're saying that it needs to be one, a part of the policy, and two, carried in schools, but it authorizes non-public schools to create a policy and have a policy framework to work from.
But your goal is to have one in public schools.
Absolutely, yes, sir.
Available. Okay. Then the other question is, it says we're going to train school nurses and school personnel. It doesn't say it, but I'm guessing, I'm hoping maybe that you're talking about people who volunteer to do this. Having been in a school and there's cardiopads and EpiPens, they would ask us, does anybody want to be trained in how to do this? And actually, I'm embarrassed to tell you, but also it's just, I can't, I tend to pass out in those situations. I tended to say no, thank you. Because for the very reasons Mr. McAllister says, I was afraid that I would not perform well. So
understood.
I'm sorry, I'm running on a bit. Go ahead.
No, it's okay. No, Delegate, that's a great question. And it's the question that we've been talking to with Dr. Wood and the Nurses Association and the School Health Nurses Association, because they do believe that they should be the trainers. The bill was written as such because in schools currently, there isn't a full-time in most schools nurse, or there's a part-time nurse. So the bill language speaks to that, to have someone appropriately designated. If in the case of Elaine Papp, who you heard her testimony, right? She was a school nurse there, but she had the tool wasn't where it was supposed to be. In this case, if she was not there, right? And the tool was in the inhaler was in an office that's locked and you can't get to, then who is the person that would be able to administer the rescue inhaler? And this is what this bill is trying to determine: who has to be that person if, one, the nurse is not there, and two, as you heard in testimony, exhausting 911 services. I mean, we want to use them if there is, but if it's an emergency, we want to be able to, kind of settle the situation and then call 911 versus waiting for 911 to get there without a medicine. So to your point, we would not pick you, so don't worry about it. But it would be, when I think of personnel, I think of the principal. I think of people like the athletic director, people who have more of a base knowledge of this, not like the math teacher who just happens to be there.
Well, the math teacher might be good. I'm just not the one.
They might be,
but the key here is that if the bill says you have to have somebody, then somebody has to be trained. We have to find a way to make sure that they want to be, and that we compensate them for the work that they put in and for the position they're holding, rather than just assuming there's somebody who wants to do this. There might be, but we really have, I think we need to drill down on that a little bit. And I'm sure you'd be happy to work with me on that. By the way, I can't let.
Absolutely. And as I mentioned, the nurses have the same question, and I'm hoping that the subcommittee can come up with something.
Speaking of the nurses, I noticed that Chair Atterbury greeted Dr. Wood. She's my constituent, Chair Atterbury. I just want you to know.
Oh my God.
And has been for quite some time. Looks like she might have jumped off, but okay, thanks. I think those are both my questions. I appreciate the time, Madam Chair.
She's your constituent. She's still on, but she loves me. So there.
Well, there's enough to go around, don't you think?
I see Delegate Guyton has a question.
Thank you, Madam Chair. I don't know Dr. Wood very well. I'm sure I would love her as well. I do, however, love my friend Delegate Boyce for bringing this bill back again this year. And I have a question, but before I ask it, I do, I sit with my inhaler every year. when we hear this bill, because it's never far from me, because I was one of those kids who had asthma attacks in school. Luckily, being that my school was so close in this tiny town to the doctor's office, less than 5 minutes away, I just kept going straight to the hospital. And it's very traumatic. It's horrible. And if we had had one of these little things, which costs hardly anything, and to speak to Delegate Eversol's question about training, 5-year-olds do this every day. So including that, me, my whole life. So it's very, very simple. It's very, very inexpensive. And I hope we can move on it. But I do have a question. You mentioned at the beginning a bill that Congressman Hoyer put in to help provide grants for these sorts of medications. And I did step away for a minute, so I apologize if someone spoke to that. How would that pay, even though they're not expensive? Would that pay for these? Is that something that we could utilize?
That could, and I would like if Charmaine's still available to speak to that, because she worked with the congressman closely on this bill. And I know she mentioned that they're looking for funding, but I'll let Charmaine, if it's okay with the chair, to pass that question on to Charmaine.
Yes, go ahead, Ms. Anderson.
Delegate Guyton, so Standing Majority Leader Hoyer's bill, initially when he introduced it about 2 years ago, it did allow for the purchase of medication. Through the iterations of Congress, they have now changed the legislation, which became law, to really emphasize the incentive of getting states more engaged on having schools develop asthma action plans. With that being said, the incentive is through the National Asthma Control Program, which currently there's about 20 some states that receive direct funds for that program through CDC. Maryland is not one, which I understand through the years ago, it was a recipient of National Asthma Control Program funding. So currently, the bill just allows the incentive through that National Asthma Control Program to receive grant funding, which in turn will allow a state to help manage, kind of basically set the program, and whether that entails purchasing medication and or just helping establish the framework of the program, it will allow you to do that. But it just was not written in law. That is then determined kind of stateside, how the states set their programs up and what CDC approves. But we currently are working with Majority Leader Hoyer to not only get additional funding into CDC's program, because that in turn not only allows for more money to go to the recipients of the program, but it opens the window, because we're pushing for them to open the door to allow for more states to actually get funding. We're hoping at least get enough funding for another 4 states to get asthma control program funding. So there's this twofold thing, but again, we just got to make sure that, if this bill passes, this bill then sets the state up in time to be able to access and be kind of in front of the line for asthma control program funding through CDC, if that makes any sense. And I'm happy to answer more questions offline.
It does. Thank you so much, Ms. Anderson. And pass along our appreciation to the congressman as well.
Absolutely.
He does great work. Thank you. Thank you.
Any other questions? Okay, seeing no further questions, that concludes the testimony on House Bill 384. Thank you, Delegate Boyce. Thank you, everyone.
Thank you, Ways and Means.
That concludes the bill hearings today for the Ways and Means Committee. Ways and Means, we will be meeting at 4:30. I'll give you 15 or so-ish minutes, 4:30 for a very quick